All right, good afternoon. Welcome to the House Environment and Transportation Committee, Thursday, February 5th, 2026 bill hearings. We will start with our departmental from the Maryland Transportation Authority, HB 246, video tolls, Class G trailer vehicles liability. I think we can bring up Mr. Gartner, and if you have a panel or anything.
With me. Good afternoon, Chair, members of the committee. My name for the record is Bruce Gartner, Executive Director of the Maryland Transportation Authority. I'm here to testify today in support of House Bill 246, which is our departmental bill. This bill would authorize the MDTA to toll registered owners of Class G vehicles or trailers. If the registered owner of the motor vehicle cannot be determined through either an Easy Pass transponder or an image of the front plate, the front license plate. Currently, MDTA only tolls motor vehicles, so those trailers are not classified as motor vehicles. The motor vehicle definition in statute is as a vehicle that is self-propelled and not operated on rails. House Bill 246 would authorize us to toll registered owners of Class G vehicle as a last option. If an image of the front or rear license plate of the motor vehicle towing the trailer cannot be captured, for instance, if the plate is obscured or missing. There are numerous states that do not require front license plates for non-commercial vehicles, such as Delaware, North Carolina, Pennsylvania. And currently, if a passenger vehicle from one of these states does not have a readable transponder and is towing a trailer that blocks the rear license plate, there is no way to collect tolls for travel on a toll facility. The MDTA estimates that it loses approximately $11 million annually in uncollected revenue from 3+ axle vehicles due to the inability to notice that owner of the trailer Class G vehicle. This bill would assist us in capturing this lost revenue and offer fairness to those people with transponders and paying their tolls to the MDTA. As I mentioned, it is MDTA's intent to toll these vehicles as a last option when a motor vehicle's license plate cannot be captured and there is no valid transponder. The read on the vehicle of the for that trailing vehicle does not have transponder. We met with stakeholders, and after hearing their input, we do support an amendment to codify what would be our practice in the bill text, in addition to doing COMAR changes. I think you have some testimony from the Maryland Motor Truck Association to that effect. House Bill 246, if it is enacted, Maryland would not be alone in our practice of doing this. There are other states such as Kentucky, Ohio, Pennsylvania, and Rhode Island that use license plates on Class G vehicles for tolling purposes when needed. This legislation received the approval of our board at its December meeting. We are intending on setting the effective date on the January 1st of 2027 to give us time for an education campaign, because really we want is compliance and to be able to have all the folks that are trailing these vehicles understand the legislation and how it will be enacted. Thank you for your time. We do request the committee do a favorable consideration of House Bill 246, and with that, Heather and I are available for questions.
Thank you very much. Are there any questions? Delegate Anderson.
Thank you, Mr. Chairman. Has someone that owns a lot of trailers, don't even know where they all are or who's pulling what, on the form that you would send me if one of my trailers went through, would you have consider on the form that I could put the person that's responsible there?
Yes, sir.
Okay, because
yeah, there'd be requirements for transferring that liability and some documentation, but yes, that is we do that, and that's the intent to get out that kind of education, get those forms easily available to people in the notice.
Because not just me, but other family members and all that. You know, everybody borrows whoever's got a trailer that doesn't have flat tires and the brakes work and the lights work. The whole community wants to borrow it, so.
Just ask them if they have a transponder first, and you should be good, right?
All right, thank you.
Delegate Odom.
Yes, you may have stated, if so, forgive me.
No,
but there are other states that actually do this, correct? Could you mention some of those that do it successfully?
Yeah, for other states, Kentucky, Pennsylvania, Rhode Island, and Heather with Ohio are the 4 other states that do this. Yeah.
Delegate Long.
Thank you, Mr. Chair. And my district mate was kind of getting into my question, I want to go a different angle just to make sure I'm clear. So it's referencing, you made reference to the front license plate. And are you saying that because some states don't have a front license plate, it makes it arduous for you all to be able to capture that information? So therefore, that's why you're asking for?
Correct, because if they have a trailer, we're not seeing a rear plate. We're only seeing a rear plate if the trailer has it of that trailer. So again, $10 million loss, we thought it was something that should be presented to the committees in the General Assembly to consider.
Okay, so you believe the front license plate is the reason as to why?
Right, so if they have a transponder or a front license plate, this doesn't come into play. We capture that information, and they pay the toll for that vehicle and the trailing vehicle.
Okay, thank you, Mr. Chair.
Okay, thank you very much. That concludes the bill here on House Bill 246. We'll turn to our colleague Delegate Foley. House Bill 30, Public Safety, Department of State Police, police-initiated towing alterations.
I'll turn on your mic, don't worry. Who's going first? Yeah, okay. Hello, good afternoon, everybody. This is another towing bill, surprise. Good afternoon, Chair Corman, Vice Chair Guyton, and the members of the best committee in the House, the Environment Transportation Committee. Thank you for the opportunity to present this bill today. For the record, I'm Delegate Linda Foley, and I'm presenting House Bill 30, which defines quote-unquote light-duty towing and establishes guidelines for light-duty towing and recovery rates. I'm also presenting a proposed sponsor amendment to the bill, which sets more concrete guidelines for light-duty towing rates and adds additional responsibilities for the Committee on Rate Setting and Complaint Resolution for police-initiated light-duty, medium-duty, and heavy-duty towing and recovery to examine issues with insurance and cargo cleanup. So this commission is a commission that we established as a committee 3 years ago, I think, maybe 3 years ago, to deal with rate setting on some of these issues related to police-initiated towing. So first, under current law, the Maryland Department of State Police establishes maximum rates for police-initiated medium and heavy-duty towing and recovery. So House Bill 30 adds light-duty towing alongside these existing responsibilities, establishing clearer guidelines for approved towing companies. The proposed amendment would also require that light-duty towing rates not exceed 80% of the maximum rates for medium-duty towing and recovery. So for medium trucks, essentially, whatever the rate is for that, this cannot exceed 80% of that. This amendment would assist the Maryland Department of State Police in establishing fair maximum rates while protecting consumers from overcharging. Second, the Maryland Insurance Administration, and this is part of the amendments, the Maryland Insurance Administration currently requires that the at-fault vehicle's insurance cover the cost of cargo and debris cleanup after an accident. However, in situations where the at-fault driver's insurance does not cover these cleanup costs, towing companies are left to bear the expenses themselves. Towing companies have also faced significant challenges receiving payments and resolving insurance matters for vehicles registered, insured outside of Maryland. So, with the proposed amendments, House Bill 30 would direct the existing Committee on Rate Setting and Complaint Resolution for Police-Initiated Light-Duty, Medium-Duty, and Heavy-Duty Towing and Recovery to examine these situations and make recommendations to assist authorized towing companies in addressing them. This existing committee already convenes the appropriate stakeholders, including members of the Towing and Recovering Professionals of Maryland, who are here today, representatives from the Maryland Transportation Authority Police, and representatives from the Maryland Insurance Administration, including also representatives of the trucking industry, making it the ideal committee to efficiently develop solutions to these insurance issues. In summary, House Bill 30, with proposed amendments, delivers meaningful benefits to the Maryland Department of State Police, approved towing companies, and consumers by ensuring that police-initiated towing in Maryland protects consumers from overcharging while preventing approved towing companies from being forced to bear costs that insurance should rightly cover. This legislation was drafted in collaboration with the Maryland Department of State Police, and you'll see in their testimony that their concerns are addressed by the amendments, and the towing and recovering professionals of Maryland. I urge a favorable report on HB 30, and I'm happy to answer any questions. Thank you.
Great. Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. Andrea Mansfield with Manus Canning and Associates. I'm here representing the towing and recovery professionals of Maryland. And really want to thank Delegate Foley. As you know, she's had a few towing bills for us now. I think TRPM actually should get you like a gold tow truck or something that you can put on your desk. I really appreciate your assistance. Okay, we'll get that. But yeah, I think Delegate Foley did a really great job describing the bill and the amendments. And actually, this really is an outgrowth of the work that TRPM has been able to do with state police since that towing committee was put in place. I think that committee worked very well for talking through issues of setting maximum rates for medium duty and heavy duty towing. And actually, TRPM has really developed a really great relationship with state police to address towing matters that come through that department. The light duty towing area was one piece of it where there weren't any rates set. And with some of the questions that would come in or complaints, MSP working with the TRPM really felt that there should be some better parameters around that. So we really see this really as a consumer protection bill. It's designed to kind of provide more guidance and uniformity for rates charged for light duty police tows. So we really see that as a good thing. As Delegate Foley indicated, the state police did have a couple questions. They wanted to provide some better clarity around what that maximum rate would be. They also wanted the towing committee, I'm not going to say the tongue twister name, sorry, but they wanted that committee to kind of help play a role in that process and make a recommendation to the superintendent to set those rates. So we addressed that through the committee, through the amendments. There's a couple cleanup amendments that dates were no longer relevant, and the other two pieces were really involving the insurance matters. Quite frankly, we had been talking with Delegate Frazier-Hidalgo about some of the insurance issues, but frankly, these get very complicated when you get into the nitty-gritty details of individuals that are insured out of state, and also just the cleanup of the debris and how that would work in interstate commerce. So we really felt this was kind of a win-win. It gave a forum to have the discussions with all parties at the table to work through all of the issues. With that, we really appreciate your support and urge a favorable report on House Bill 30 with the sponsor amendments. But thank you.
Charles Parrish, Legislative Chairman for the Towing Recovery Professionals of Maryland, and great job, me too. Me too.
Great testimony. Delegate Long?
I am so full of questions today because this is a matter of concern to me, and I appreciate you bringing the bill forward. So in certain instances, for example, I've had a constituent, they got into a car accident and the state police automatically towed the car to a facility. They had no say in where the car went to. The rates were astronomical, so I'm assuming that this would help prevent the monopoly that I guess tow companies have had and placing burdens on folks who are in that predicament.
I believe, so I can let actually
Charlie respond to that.
Actually, this is the main reason why, because we're against this. It makes us all look bad. As I've said many years as I've been coming here, nobody wakes up to see Tow Truck Charlie. Nobody has them in their budget. My name's Charlie. Nobody has it in their budget. So for whatever reason you're being towed, and the state police have been doing a great job in getting their directives too because of the work that Delegate Foley has done with the bills that she's passed. Actuality, the way it should be when you have an accident and the state police call that tower, if you haven't called your own, and that tower shows up, you are allowed to decide, and these rates are set that if you wanted to go somewhere else, it doesn't automatically have to go back to our lot. And these rates will help that because light duty was left out.
Right.
Because it was a commercial that when we first started. This will prevent those nightmares that you're hearing about, yes.
Great, thank you again. Thank you, Mr. Chair.
Great. I do not see any further questions. Oh, I'm sorry, Delegate Lewis.
Thank you. Thank you, Mr. Chair. Thank you, Delegate Thomas, for this week. I have one quick question. The bill, the language in the bill, I have the original bill, I'm sorry I don't have the amendments, but the original language in the bill says, the approved rates for light-duty towing and recovery may not exceed a percentage of the approved rates for the medium-duty towing. I guess you leave it up to the agency. How will the rates, what's the formula? How will that be handled?
Yeah. Thank you, Delegate, for that question. The amendments address that.
Oh, great.
So
Thank you.
the amendments set it at 80% of the medium-duty training rates, or medium-duty towing rates.
That the board will not be able to go above. So the
yeah,
board will
right.
decide a maximum, just as we did with medium and heavy, but no matter what we decide, it cannot go above 80% of the rates that are presently in place for medium,
Great.
which
Thank you
is
so
the
much.
next weight class.
Thank you very much.
And I'm sorry, I forgot to mention, we have, the amendments have been shared with the Insurance Administration, Maryland Motor Truck, as well as the American Property and Casualty Insurance Association, and they are all fine with the amendments. Thank you.
Great. I do not see any further questions. That concludes the bill hearing on House Bill 30. We're going to go to House Bill 23, Delegate Woods. Motor Vehicle Administration Identification Cards Issuance to Minors.
Thank you, sir.
Good afternoon, Chair Corman, Vice Chair Guyton, and the esteemed members of this Environmental and Transportation Committee. I'm Delegate Jamila Woods, here to request a favorable report on House Bill 23. This is legislation that improves access to state-issue identification cards for minors by removing the unnecessary procedural barriers and then maintaining compliance with federal law. Access to a state-issued identification card is fundamental for our young people. It often determines whether they can enroll in school programs, apply for jobs, access health care, secure housing services, or participate fully in their communities. Yet for many minors, particularly those who are unhoused, in foster care, estranged from parents, or living in unstable family situations, current MVA requirements make obtaining a legal ID unnecessarily difficult. This issue was brought to my attention in the 2025 session by Omari Barnes, who is here with me today, a high school student who experienced firsthand the shortcomings this bill seeks to address. His experience highlighted how rigid requirements such as mandatory parental presence or co-signature can unintentionally exclude minors who are otherwise eligible but lack consistent adult support to receive an identification card. HB 23 responds directly to those realities by allowing minors who are at least 15 years old to apply independently by expanding the types of documentation used to establish residency. House Bill 23 does not weaken safeguards. It modernizes policy to reflect real-world circumstances. The bill requires the Motor Vehicle Administration to adopt clear regulations identifying acceptable forms of residency documentation, including school records, child welfare agency records, court documents, and documentation from homeless service providers. These are records which already exist and are routinely relied upon in other contexts to establish identity and residency. Importantly, HB 23 preserves Maryland's commitment to federal compliance. When a minor is unable to meet the requirements of the Federal Real ID Act, the administration retains the authority to issue a non-real ID compliant identification card. This ensures the state remains compliant with federal law while still providing minors to access essential identification. I want to take this opportunity also to recognize Delegate Vaughn Stewart, who previously served on this committee when I tried to put this legislation forth last year. His leadership and support were instrumental in helping our office navigate the complexities of Real ID compliance while ensuring the state continue to serve vulnerable populations with care and flexibility. His guidance reinforced that compliance and access can coexist. House Bill 23 reflects that balance. It acknowledges the administrative needs of the state while ensuring young people are not denied basic information due to circumstances beyond their control. For these reasons, I respectfully urge this committee to issue a favorable report on House Bill 23. Thank you for your time and consideration, and now I'd like to turn it over to Omari Barnes himself.
Thank you, Delegate. Chair Corman, Vice Chair Guyton, and members of the Environment and Transportation Committee, good afternoon. First, while I do serve as the student member on the Maryland State Board of Education, my testimony today is offered in my personal capacity and not on behalf of the board. Now to the meat of the matter. I appear before you today to respectfully urge a favorable report on this bill, of which I am the originator. When I initially reached out to Delegate Woods last session, I was facing a significant obstacle. A few months prior, I had visited my local branch of the Motor Vehicle Administration, accompanied by my great-grandmother, who, following my mother's departure in my early infancy, assumed the role of my primary caregiver. Although present in my life, my father never formally acknowledged paternity on my birth certificate, which is a circumstance that is beyond my control. Furthermore, approximately 5 years ago, he relocated 50 miles away from my residence to St. Mary's County. I live in Prince George's County. These circumstances do not reflect a lack of character or judgment on my part. Rather, they represent situations that affect thousands of Maryland youth residing in non-traditional or kinship care households. My great-grandmother and I were denied service at the Motor Vehicle Administration because of this. Current regulations mandate the physical presence of a biological parent at the time of application for an identification card. Additionally, without my father's name on my birth certificate, which that parent is also required to furnish, I was unable to obtain identification absent legislative intervention. And that intervention became necessary through Delegate Woods. The MBA demonstrated a lack of commitment to equity by granting my identification only as a favor to Delegate Woods. I implore you to ensure that access to identification is not a privilege, but an accessible right. That same summer, my father tragically passed away as a result of an unforeseen accident. If Delegate Woods had not intervened, it would have become physically impossible for me to obtain an ID until my 18th birthday, a juncture that would have prevented me from traveling, securing employment, or exercising my right to vote. This bill would eliminate these obstacles by prohibiting the MVA from imposing the current requirement while simultaneously, as the delegate mentioned, maintaining rigorous standards for the verification of identity and citizenship, including proof of age, social security verification, and 2 proofs of residency. For these reasons, I urge you to take decisive action on behalf of the youth you serve and to vote in favor of this bill.
Thank you so much. Any questions for the sponsor or the panelist? Just thumbs up. Okay, great. Thank you both very much. There is a virtual favorable witness. We have Jennifer Stein from CASA of Baltimore County. Please go ahead when you're ready.
Thank you. Good afternoon, Chair Corman, Vice Chair Guyton, and members of the committee. I appreciate you taking the time to hear this bill and allow me to speak. My name is Jennifer Stein. I'm the Executive Director for CASA of Baltimore County. We are the CASA that is court-appointed special advocates. We work with youth in foster care. I am here on behalf of the Coalition to Protect Maryland's Children and speaking from the perspective of supporting and advocating for youth in foster care. As Delegate Wood and Mr. Barnes have already expressed, expressed, having access to an ID is incredibly important. And for youth in foster care, there are so many ways that they are already at a disadvantage. This bill is actually one step toward ensuring that they have the opportunity for success. As we have heard, and as you all probably know, IDs are required for getting a driver's license, enrolling in school, opening a bank account, and or cashing checks, getting jobs. There's also safety reasons to have an ID, particularly as youth are more and more experiencing surveillance by adults. It's important for them to be able to show who they are. And for youth in care, in foster care, they are at a significant disadvantage because the caregivers that they are living with, the foster parents, are not able to be the person who signs for getting an ID. They are not the guardian. The DSS worker is the guardian, and therefore the worker is who the youth are reliant upon to go with them, to help them find the paperwork and all those sorts of things. As we know, foster care workers have very high caseloads. They're often focused on emergency situations rather than things like getting someone an ID. Baltimore County has come up with an MVA day once a month, but that's not going to catch everyone, and it's still not the best way for youth to do it. Youth can consent to their own medical care by the age of 16, so I feel they should be able to do this as well. For this reason, it is a way to help one of our most vulnerable populations. I urge a favorable report on HB 23. Thank you.
Thank you very much. I do not see any questions. So that concludes the bill here on House Bill 23. We are going to move to House Bill 187. Delegate Allen, Motor Vehicles Intelligent Speed Assistance System Pilot Program Establishment.
Madam Chair, I'm going to bring up my panel, if that's all right.
Certainly is. Whenever you're ready, you can start. Thank you.
All right. Thank you, Madam Chair, members of the committee. Delegate Baylor's not even here. Thank you so much for having me today. It's always great to be here. For the record, I'm Delegate Nick Allen. I'm here to talk about House Bill 107, which is my bill. It's a reintroduction of a bill most of you, or at least everyone who was a member of the committee last year, heard. It's a pilot program involving intelligent speed assistance systems. So once again, just to reiterate for everyone who might not remember all of my bills, I know we hear a lot of them, but last year, the bill is very similar from last year. There's some clarifying changes and there's some possible amendments, but what it does is rather simple. For drivers who are super speeders, ones who have been ticketed so often or so much or at such high speeds that they have accrued enough points to have their license revoked, this bill establishes a pilot program that instead issues them a slightly different license, allows them to keep driving, provided they have this system installed in their vehicle. This system physically prevents them from going over the speed limit. It's GPS guided. It's remarkably accurate. I drove it around in Annapolis last year, actually. It knows exactly when you cross from 35 miles an hour to 40. It can read it. It's literally down to like the foot. It's really, really impressive technology. And it's actually not new technology. It's technology that's been used for over-the-road trucking and long-distance logistics for about a decade now. In shipping. So this is just another application for this technology. I think it's going to save lives. You know, we heard today, I think several news outlets reported that Maryland saw a really, really great drop in traffic fatalities this year, but it's still, the number we have is still greater than 0, which is our goal, right? So this is a way to, again, keep people who, might be super speeders, keep them driving safely. Let them keep their licenses so they can still take their kids to school, they can still get to work, they can still pay their bills, but it guarantees they're going to be driving safely when they're behind the wheel. I'll also note, because I think there was some misinformation last year on some of the news reports. This is a pilot program. It's only for super speeders. This is not for every driver. This is not even for every driver that gets a speeding ticket. This is for people who, again, speed so much that their license would be otherwise revoked. So with that, I'm going to turn it over to the rest of my panel. We look forward to answering any questions you may have.
Excuse me, Delegate. Thank you for presenting that bill. I think it's important for people in the audience to recognize that there is a rule in the General Assembly about holding up signs during, and I know there are a few out there, so if you could just help us follow that, and we can keep things under control. Thanks. And it could be from my bill. I can't even read it. But so this isn't about one bill or another, but that's just a solid rule here. Thank you.
Regina, go ahead.
Do you want me to go? Okay, thank you. Good afternoon, Madam Vice Chair, members of the committee. I'm Regina Ali. I'm the Public and Government Affairs Manager for AAA here in Maryland, also representing Washington, D.C. and Northern Virginia, and actually a former Baltimore police officer. But AAA is here in support of House Bill 107. We certainly recognize the tremendous danger that speeding places on our roadways. There were nearly 41,000 deaths from motor vehicle crashes in the United States in 2023. Nearly a third of those were speed related. According to the Maryland MVA, there were more than 7,700 speed related crashes in Maryland in 2023, resulting in 32 injuries and 102 deaths. AAA certainly supports requiring active intelligent speed assistance technology, or ISA, as Delegate Allen said, for not only combating repeat speeding, but for those most egregious offenders who, again, would otherwise lose their license. So we recognize the dangers. We also recognize that while this technology may be new for us here in the state of Maryland, it has been used across other states and demonstrated success in reducing speed. I can also tell you that at AAA, our Foundation for Traffic Safeties, we do an annual sort of study looking at driving behaviors. 61% of respondents recognize the dangers of driving fast, the dangers of driving, of speeding, yet 50% of them acknowledge doing so. So we certainly recognize that this is an issue. I know my time's going to wind down soon, so I will just say that much like an ignition interlock, this is one of those tools in the traffic safety toolbox that we believe will help save lives on our roadways, reduce speeding, again, for those particularly who are inclined to speed egregiously and dangerously on our roadways. And for those reasons, we respectfully urge the committee to give HB 107 a favorable report. Thank you.
Thank you. You can continue.
Thank you. Committee members, Madam Chairman, thanks for having us today. It's good to see many of you again. Some of you will know my story, the story of my wife. She was killed 3 years ago on River Road riding her bicycle when a large truck turned into her and rolled over her. Since then, I've been working with advocacy organizations to try to close the most glaring gaps in our traffic laws. And of all the bills that I know of this year, I've chosen this one to advocate for because I think it can do the most good saving lives here in our state. And here's why. First, speeding is a huge problem in the United States. It's responsible for nearly a third of all traffic deaths, and there are a lot of these traffic deaths. Nearly 3,000 people die on our roads in the United States every year. That is the equivalent of September 11th every single month in America. Second, the drivers that we are talking about are extraordinarily dangerous, responsible for a large number of the deaths that we're talking about. New York City's Department of Transportation did a study and found that people that are responsible for 20 or more speeding tickets are more than 5 times more likely to be involved in a fatal crash or a serious injury. People with 30 or more tickets are more than 50 times more likely to get into a fatal crash or a serious injury. Now, third, the current law enforcement that we have is simply not working. Studies show that more than 75% of all people who have their licenses suspended continue to drive anyway. So this law will address that. And then fourth, Washington, D.C. and Virginia already have this law. So there's no reason that someone in Maryland should be less protected than people in neighboring regions. So to be clear, this bill focuses only on the small number of extraordinarily dangerous drivers that are out there who rack up endless driving infractions like trophies and who get back on the road poised to kill again. So just finally, let me just say, you know, traffic violence is a choice that we make. We can control this with enforcement, with road design, and with good technologies like this one. Thanks.
Chair Corman, Vice Chair Guyton, members of the Environment and Transportation Committee, thank you once again for allowing me to speak in front of you regarding traffic safety, Vision Zero, and safety of all Marylanders on our roadways. I may never get away from the sergeant title, but my name is Lieutenant Pat Kep with the Montgomery County Police Department. I'm a deputy commander of the 3rd District in Silver Spring. As I've spoken about before in front of this and other committees, and you all know, in October 23, I was intentionally struck and nearly killed by an extremely dangerous driver in Montgomery County. Unfortunately, that means I can tell you firsthand how dangerous and deadly speeding is. Even modest increases in speed cause deadly changes to crash dynamics. For the majority of my career, I was assigned to the Traffic Operations Division, and now I'm back again in the Patrol Services Bureau. I routinely see people driving in excess of 100 miles per hour. As you know, the individual who struck me was going 162, and I previously stopped him for going 136. Pattern of being a habitual or chronic speeder is not unique. It's rampant in Maryland. All too often, speeding is coupled with other deadly driving behaviors such as drunk and drug driving, distracted driving, and speed, intentional reckless driving behavior. House Bill 107 looks to fill a void in Maryland's approach to speeding drivers. A person who is a license suspended for a points violation is the majority of the time a chronic speeder or someone who's convicted of other dangerous driving offenses. As I can tell you from real-world experiences, as was mentioned already, people still drive on their suspended license. House Bill 107 would ensure that these people have a legal avenue to continue driving while ensuring that they drive the speed limit to help them maintain their work and family responsibilities while keeping the road safe. I attribute this to the Ignition Interlock System program, as was already mentioned. Interlock devices decreased rearrest rates by about 67 to 70% from CDC and National Conference State Legislature studies. The devices are highly effective for both first-time and repeat offenders during the installation period, and they consistently outperform license suspensions alone. And that's where I think this program, even as a pilot program, can help to fill that gap. DC passed the law in '24, Virginia passed last year. Maryland has a chance to save lives and make our region the leader in road safety. Our work from last year is far from over, and there's significant change still necessary to ensure roadway safety work towards Vision Zero. This is an important part of the change, and I urge you to pass it out of the committee and into law this year with a favorable report. Thank you.
Thank you so much. I appreciate it. Do we have any questions for this panel? It looks like there are a few. So let's go first to Delegate Stein.
Thank you, Madam Chair, and Delegate, thank you for bringing this bill, and I certainly agree with you that chronic speeders are a menace and cause way too much death and destruction. My question is sort of a narrow one, but nonetheless wanted to ask you. There are situations where someone briefly needs to speed up to avoid an accident. You know, say car is coming, unintentionally is coming at them, so someone needs to swerve out of the way, or someone's trying to cut into their lane, and so car needs, the driver needs to speed up to avoid hitting that car. What happens in those situations?
Yeah, thank you for asking the question, Delegate. I'll say just from using the technology myself when I tested it, you can actually, when the technology is installed, a tolerance is programmed into it. So it's not just, the speed limit's 35 here, I can only go 35. You can actually adjust that to 3, 4, 5, 6, 7, 8, miles an hour over that, whatever the posted speed limit is. And it still changes when the speed limit changes. So if you're going down a road that's 35 and the tolerance is set, you could speed up to 40, 42 miles per hour or something like that in order to avoid those things.
Can I just add, the regulator determines that tolerance? MVA determines the tolerance.
The MVA would determine it. Okay, all right, good to know. Thank you.
Okay. Delegate Ziegler.
Thank you, Madam Chair. So Delegate Stein took one of my questions, so that's a good thing. But the first thing I wanted to ask you is, would you be open to an amendment that would just require this in every car? No, but seriously, I would actually love that. But I did want to ask about if there's a possibility that this could be altered or hacked, or I'm not sure how it works, but is it something that could be disabled by the speeder?
Again, I'm not super familiar with all the intricacies of the technology, but again, I think it functions a lot like the interlock system, that it's integrated into the vehicle when it's installed. So it's not like something that's plugged into the cigarette lighter, for example.
My understanding is that a hack would trigger an alarm that would notify MVA.
Okay, great. Thank you very much.
Okay, Delegate Grammer.
Thank you, Madam Chair. So refresh me, it's 12 points a person gets their license suspended. And the idea is, as an alternative to suspension in which they couldn't drive, this would be an alternative that would let them drive, but with what's the term for the device?
Yeah, it's intelligent speed assistance device, yeah.
Okay, so this would allow them to continue to drive, but with the regulator on.
Yes.
Okay, thank you.
And I'll also point out that if you guys want to glance at the fiscal note, there is none. The program is paid for by, when someone, again, has accrued enough points to have their license suspended, they can basically choose to either have license suspended or they can pay the monthly subscription for this fee, or for this device.
Right. Thank you for making that clear, clarifying that for us, because I did have a question about that as well. I know they can actually be fairly expensive, these subscriptions, but this isn't something anyone has to do.
Right.
It's a choice.
I think it's around $100 a
Correct.
month. I think that it's about $100 a month for that.
Okay. Delegate Naraki.
Thank you, Madam Chair. Delegate, thank you for the bill. I'm supportive of the idea, but I have a question about in practice. So, as you know, I have a few cars in my household. I even have some that aren't in my or my wife's name. They're in a company name, right? So I could have access to all different kinds of vehicles. I don't see anything inside of the legislation that says what happens to someone if they intentionally try to circumvent this device and they start just driving another vehicle that they should not be doing. And look, some people like to break the rules. If they're a habitual rule breaker, they've gotten so many tickets here that they're in this circumstance. What's to say that they wouldn't be a habitual rule breaker to just go drive another vehicle if they have access to it? So I would just be curious, like, what your thoughts are on, look, I think that if they did that, they should get a very serious penalty for that. So I just kind of want to get your thoughts on that.
Yeah, I mean, I don't want to speak for the MVA, but I think, well, first of all, we're either like previously was said, 75% of people who have license suspended keep driving anyway. So just by having this as an option in one of their vehicles, I think that decreases that. But I'll also say, part of this is the MVA actually issues them like a different license. So if they are pulled over driving a vehicle with a different license, then they're identified as driving the wrong vehicle, frankly.
Madam Chair, so with that, is there, and I don't know what the rules are right now, is there an additional penalty then if already in statute that someone would get for that? I'm just trying to clarify that point of it.
It's very similar, or I believe it would be very similar to the ignition interlock program. So you have if you're required to have an ignition interlock, can't say that 3 times fast. You have it shows a J restriction on your license. Flip the license over, it says ignition interlock required. So if you are driving and it says if you wish to drive, well, you may have 5, 10, 15 vehicles. The vehicle that you choose to drive has to have that interlock in it. If you don't operate that, it's a whole nother charge. In the case of the interlock, it's a $500, 60 days maximum penalty for operating a vehicle without that interlock. So that restriction on the license mandates that while you may have 15 vehicles, if you are driving on that restriction, you have to drive a vehicle that has it. So I think this would mirror that. And then to the other question, circumventing it or anything like that, there's also another law in place for the interlocks that if you circumvent the system, there's an additional penalty for that. So I believe the intent is to pretty much marry the interlock system with the ISA system.
Okay, perfect. Thank you. That helped.
Thank you so much. Now I'm going to turn it over to our subcommittee chair for transportation, Delegate Lewis.
Thank you, Madam Chair. This is a very exciting day for me, all the transportation bills. Thank you, Delegate, for bringing the bill. Thank you to your panelists. To the gentleman who lost his wife, we're very sorry, and we want to prevent that ever happening to anyone else. I'm curious about a couple things to the sponsor. Assuming you've spoken with MVA and they're supportive, I didn't see any testimony from them.
I don't know if MVA submitted testimony. I know, I believe MDOT's supportive.
Okay. Didn't see any testimony at all, so maybe we should look into that.
I will.
I'm also curious about how many do you have an estimate? How many Maryland drivers might be eligible for this option? And I understand your bill creates an option for people who could be suspended to
Right.
choose and is this also called a speed governor? Because that's a term I've heard.
Yeah,
Is
there's
it the same
different,
thing?
yeah, there's different terms for it, yeah.
Yeah, okay. But about how many might be eligible for this option?
That is a good question. Yeah, that's what I'm looking. So, looks like the estimated participants in this would be around 700.
Okay, not insignificant.
Yeah.
Okay, and I'd be interested to know how many might choose it. So I'm not sure, I don't see a reporting requirement. So one of the things that's worth doing when we implement new policies is to learn from them. Are they working? Are they is the juice worth the squeeze? So do you think you might be open to a reporting requirement so we could learn from the program if the bill should pass?
I'd absolutely be open to it. I think part of the reason why, we kind of kept this bill lean in order to not have a reporting requirement, number one, just being a pilot program, I think there's kind of reporting implied, but also, again, we're all striving for the lowest fiscal note possible this year. So I can imagine any reporting requirement would see a price tag, but I would be absolutely open to it.
Appreciate it. Thank you.
Delegate Anderson?
She got it.
You got your question has been answered. Thank you, sir. Delegate Odom.
Thank you, Madam Chair. Just one question of clarification, because it speaks to violations of excessive speed. I'm going to assume that there may be some individuals that may have a culmination of violations, speeding, reckless driving, we can go on and on, or driving intoxicated. So can you clarify that? Because this just says if you're an excessive speeder. So does it just speak to that solely, or if someone you understand my question?
I do. So in the text of the bill, what we're going for is if an individual has accumulated points in an amount that would result in suspension or relocation of their driver's license due to any combination of, and then all the subtitles that are speeding and reckless driving based. I don't have all the subtitles exactly memorized, but I believe that's what they are.
Okay.
So this wouldn't necessarily be, for parking violations or something like that. It's not those kind of points.
All right, and Delegate Anderson, you did not have another question, is that right? Could you just push your button for a second? They'll turn that off. Thank you so much. Seeing no more questions for this panel, can I ask, first of all, thank you for being here, Mr. Langenkamp. Again, we are so sorry for what happened to your wife. And Officer Cap, thank you. We're so glad you're able to be here with us and you can continue to advocate for these really important traffic safety issues. It is important that you're here and it does make a difference. Thank you very much. Is Mr. Corin with us in the, there you go. So does someone want to make room for Mr. Corin? And then we also have a virtual favorable testimony.
I'll be brief. John Corn, Bicycle Advocates for Annapolis and Anne Arundel County, but today representing a coalition of safety advocates from across Maryland. I will only add that for vulnerable road users, people defined in statute as lawfully traveling outside of a vehicle, people on foot, people on bike, people on motorcycle, people using assistive devices, are especially vulnerable to speeding. We know two things about speeding. Increases the likelihood of a crash, and especially for VRUs, increases the severity of consequence, injury or death. So you're going to hear from me several times today about anything that we can do to mitigate speeding on our roads, especially for the most vulnerable. Thank you.
Thank you so much. So now I'd like to call on Mr. Galula, who should be with us virtually. Are you there, sir?
Hi there.
You can
hear
start
me?
whenever you're ready.
Yes. Hi there. My name is Joseph Garuda. I am testifying on behalf of Montgomery County Council Member at Large, Lorian Sales, who unfortunately was intending to testify but had an urgent conflict. But we're rising in support of this bill and thank the delegate, Nick Allen, for introducing this critical legislation, because this isn't just a traffic safety issue, this is a justice, equity, and public health issue. We asked this body to pair evidence with action. Montgomery County's Vision Zero FY25 report makes clear that despite our infrastructure investments in roadway safety, we have a lot further to go in terms of ensuring safety for everyone who uses our roads. Roadway crashes and fatalities have been elevated since the pandemic, and in 2024, we saw a record number of fatalities. These local realities mirror national findings. Research compiled by Families for Safe Streets found that speeding contributed to nearly 12,000 deaths in 2023, and it also showed that requiring high-risk drivers to use these very types of devices can reduce fatalities by as much as 50%. And as we've heard of tragic examples from other testimony today, these aren't numbers, these are lives. Every statistic is a story of a life shattered, a preventable tragedy. Just last September, a 16-year-old girl was struck and killed along University Boulevard in Kensington. That's a future forever robbed from our community. And it's not just because of the actions of a particular driver, but it's because our policies are falling short. While that road has been designated a state highway, a pedestrian safety priority by the State Highway Administration, and the council recently adopted a master plan to improve roadway safety along other sections of the road, these infrastructure-based safety improvements take time, and we need action that is based in fact now. So that's why we would support this bill. And yeah, we also support this bill because we think it's a powerful tool for equity. It provides a path forward for people who have their licenses taken away, and it waives fees for those who can't afford them. Thank you very much.
Thank you very much. I do not see any questions. So I believe that concludes the bill hearing on House Bill 107. I apologize to my constituent for being out of the room during your testimony. And we will now turn to House Bill 177, Delegate Polakovich-Carr, vehicle laws, bicycles, play vehicles, and unicycles, crosswalks.
Mr. Chair, could my sponsor panel please join? They're welcome to come up. And actually, just a procedural question, Mr. Chair, before we begin. I do have a graphic that helps explain my testimony. We checked with committee staff beforehand. Is it okay for my intern to hold that up during my testimony? There was a little bit of, I just want to make sure I'm not going against what Madam Vice Chair said.
You shared it with, yes. Yes.
Okay, thank you. All right, well, with that, good afternoon, committee. It's great to be before you for the first time this session. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 177. This bill is an identical reintroduction of a bill that this committee and the full House passed unanimously last session. The bill is about making roads safer for bicyclists by allowing them to cross an intersection at the same time as pedestrians who have a walk signal. In other words, when pedestrians get a walk signal, you can go through the intersection, bicyclists could also go through the intersection in a parallel direction, even if the traffic light is still red. I'll direct my committee's attention to the graphic that my intern Paige is holding. So as you can see, we're talking about cyclists and walkers moving in the same direction as one another, not perpendicular to each other. So if a cyclist needs to make a turn, they still have to yield to pedestrians, just like under current law. Thank you, Paige. Other U.S. jurisdictions have adopted policies like this one, and the data from those places indicate that this is a very effective policy at reducing fatal and serious crashes involving pedestrians and bicyclists. I'd also just like to point out the fiscal note. There's no cost to the state and actually a potentially large savings for local governments through eliminating the need for installation of special signage at particular intersections. We do have written support from MDOT. You're going to hear from some other advocates. I do very much thank the committee for your consideration. Thanks. Good afternoon, Chair Corman and members of the committee. My name is Haley Peckett. I am the Deputy Director for Policy at Montgomery County DOT, and I'm here to request your favorable report on HB 177. As Delegate Polakovich-Carr just noted, this is really key in terms of benefiting, giving bicyclists the same extra visibility that pedestrians already receive when they are at these intersections with lead pedestrian intervals, or LPIs. So she explained what an LPI is. This bill would primarily have benefits in areas where local jurisdictions or the state have already installed LPIs. And so in Montgomery County, we've really pushed to increase the use of LPIs. It's a huge advantage for pedestrians in terms of giving them extra visibility and reducing those conflicts and those crashes, really dangerous crashes in the intersections. HB 177 gives this benefit of extra visibility to the cyclists without any added delay. There's no extra signal time. Motorists aren't sitting in traffic longer. There's no disadvantage to pedestrians either. There's just that added safety benefit to cyclists. So it's noting in the past 2 years, the county has added LPIs to nearly 200 intersections in a way for us to try to make our roads safer for pedestrians. Specifically, when we want to extend that benefit to cyclists, we have to add signage, which adds expense, and this would allow us to confer that visibility and benefit without additional expense. I personally, when I'm out cycling and I'm out there with people of all ages, I'm not the fastest. The car can get from 0 to 30 miles an hour in a second, but it would take me a few seconds to get there. So this bill allows me to start accelerating, get that extra visibility, which is especially important if I'm cycling with people of different ages or abilities. Just quickly note that legislation passed in New York City about 7 years ago, and there has been data showing that serious injuries and collisions at intersections are way down after that legislation. Thank you for your consideration.
Great. My name is Joshua Feldmark. I am here on behalf of Bike Maryland and a coalition of cycling enthusiasts and advocates from across the state. For those of you who know what I do professionally, I think it's important to say that I'm here on my personal time and not my professional time. And with that, since you passed it unanimously by, I think, significantly larger margin than like the state fossil and everything else, and you've now been told what it does, I'm just here in case you have any questions.
And Delegate, is John Corn on your panel as well?
He's not, but he's welcome to come out.
Can I just bring up just for sake of time? I don't think it's going to be too contradictory to what you said, so.
Thank you, Chair. I'll be brief as well. John Corn, Bicycle Advocates for Annapolis and Anne Arundel County. I'm on the coalition that Josh mentioned. I'll just convey a message from my counterpart at Bikemore in Baltimore City that they would expect also to gain the same fiscal benefit of actually saving money for local jurisdictions if this is implemented. Please pass the bill again. Thank you.
Thank you. We have a question from Delegate Foley.
Thank you, Mr. Chair. I'm a little confused from reading the fiscal note, and maybe you can clear it up for me. Does this include scooters and mopeds?
Yeah, in Maryland statute, scooters, electric low-speed scooters have the same rights and responsibilities as bicycles. So I would expect, yes, it would apply.
Yeah. So how would this work? Somebody's zipping down the sidewalk, right? They come up to a signal, and I mean, explain to me. I assume that the assumption is that these vehicles are on the sidewalk already. No, they're in the roadway.
They're in the roadway. Already under state law, if a bicyclist or someone riding some other kind of vehicle, like you're talking about, like a scooter or skateboard, whatever, is riding on the sidewalk, they already have the legal right under state law right now to go through the crosswalk with the pedestrians. We're talking about folks who are in the roadway or in a bike lane. So really, it's just under any circumstances that bicyclist has the ability to go with the pedestrians, whether they're on the sidewalk or in the road. Right now, it's dependent on where they're riding.
So if I'm on a scooter, which is a vehicle I hate. If I'm on an electric scooter, all right, and I'm going down the highway or the road, and I come to an intersection, and pedestrians are waiting to cross, I can go with them, and I can zip in and out of them and go through that crosswalk and then go over to the other side. Is that what you're saying?
I think in the situation you're talking about, that if that scooter's in the roadway, they're going to stay in the roadway. They're going to stay in the lane. So under this bill, we're just saying, like, if you're in a bike lane, you're in a normal lane of traffic, you can go with that walk signal. It's not about you entering, say, the crosswalk to physically be with the pedestrians. It's just you're all proceeding through the intersection in your own space.
Except that, isn't it true that the vehicles might prevent me? The vehicles that are stopped might prevent me from not going in the crosswalk.
I don't understand the question.
Well, the vehicle's stopped by the crosswalk.
If there's a vehicle stopped and you can't approach the intersection, then there's probably no benefit unless if you have to be already at the stop sign
then you could get the head start. So if you can safely go past that vehicle, you also have to yield to other vehicles and pedestrians. So you wouldn't be able to weave through legally. The cyclist would not be able to weave through the crosswalk.
Okay, thank you.
Additional questions? Delegate Odom.
Yes. Just after that last explanation, I got a little perplexed, only because I was thinking of the illustration that was held up, and I may not have seen it quite clearly, but it did show, I think, the bicyclist that was in the roadway. So this wouldn't perhaps give the bicyclists an opportunity, if they were behind several vehicles, to then get on the sidewalk, which is legal, correct?
Right, so I mean, I am an avid cyclist too, like the other folks who are up here, and I'll say an intersection that I am often going through on my normal route crosses a 6-lane roadway, Rockville Pike, which is interstate or Route 355, and yes, that is frequently true, whereas I'm approaching that light, there are multiple cars in front of me. Legally, I am not allowed to swerve in and out of those cars to try to get up to the front of the line. So if I'm sitting there at a red light behind 3 or 4 or 10 cars, I just have to wait back there. So even if this bill becomes law, it wouldn't change anything with that circumstance. It's only when we're talking about the bicycle is at the front of that queue of cars waiting at the red light.
So in that example that you just explained, another question is, would it be legal for that bicyclist to then opt to be on the sidewalk when there's a change of the light?
Under legislation that this committee passed, I think this last session, Jay's Law, that's right. Local jurisdictions can prohibit bicyclists from riding on the sidewalk, but by default, bicyclists are allowed to ride on sidewalks.
So in those cases where there's no prohibited law in place, a bicyclist could opt to, okay, I'll get on the sidewalk, go along with traffic or with the pedestrians, and then do whatever.
Yes.
Thank you.
Okay, thank you very much. That concludes the bill hearing on House Bill 177. We'll now turn to House Bill 110, Delegate Taveras, motor vehicles, school buses, seatbelts. Delegate, if you have a panelist or anything, please bring them on up.
Thank you, thank you.
We'll keep this quick. Thank you, Chair Corman. Dear Honorable Chair Corman, Vice Chair Guyton, and esteemed committee members, and I'm imagining some of the members from Ways and Means, I don't know. Okay, so for 2 years, this committee supported this bill, and I thank you for that. This year, we made a minor adjustment delaying implementation until after 2029 and included an amendment to protect protocol, to protect school bus drivers while keeping the core of the bill intact. School buses transport thousands of Maryland students daily, yet they lack a basic safety feature that has been standard in personal vehicles for decades: seatbelts. The National Transportation Safety Board has repeatedly found that compartmentalization alone is insufficient, particularly inside impact crashes and rollovers. The NTSB is an independent federal agency established by Congress to investigate all civil aviation accidents in the United States, as well as significant incidents in other modes of transportation, including railroads, transit, highways, marines, pipelines, and commercial space. Its main responsibilities include determining the probable causes of these incidents and issuing safety recommendations to prevent future occurrences. Additionally, the NTSB conducts transportation safety research and provides support for accident victims and their families. The agency investigated multiple fatal school bus crashes that highlight the need for seatbelts. And it had them reach their determination in December 2024, that this should be a mandatory feature in all school buses. 9 states, including New York, New Jersey, and Texas, already require seatbelts. The NTSB continues to recommend that states, including Maryland, mandate lap-to-shoulder belts in all new school buses. This, as some of you may know, this bill was inspired by a now 12-year-old Montgomery County student concerned about her safety. That was 3 years ago. Bluebird, a major school bus driver manufacturer, now provides seatbelts at no additional cost, removing cost as a barrier. However, if we price out the new seatbelts, the more we wait, the more expensive it gets. This year, to add seatbelts, it's nearly $14,000 added on, when it used to be, when we started this process, at $10,000. Ensuring student safety must be our priority. I urge this committee to act to issue a favorable report on HB 110 and take this necessary step to protect Maryland's children. Thank you.
All right, good afternoon, Chair Corman, Vice Chair Guyton, and members of the committee. My name is Jeff Thompson. I'm the Director of Transportation for St. Mary's County Public Schools, and I'm asking for a favorable report on House Bill 110. So school buses are safe. However, seatbelts make a school bus safer, and that is supported by our federal agencies and also many national associations. Timely, there was an article this week in School Transportation News citing a recent survey study done in California on their seatbelt requirement. The study concluded that seatbelts have significantly reduced the number of pupil passenger injuries over the last 20 years. I believe they said pupil passenger injuries are down about 75%, and they believe it's attributable to seatbelts. So I highly recommend, if you get a chance, to take a look at that article. Aside from the advocacy for seatbelts themselves, I want to emphasize that it's crucial to establish protections for our school bus drivers that own and operate school buses with seatbelts. School bus drivers and school systems will strive to have their students wear seatbelts, but we know that it's impossible to enforce at all times. But we want to make sure we protect our school bus drivers from the unintended consequences. As we all have learned over the last several years, school bus drivers and CDL drivers in general are in high demand and short supply. So we must do what we can to support them while providing this added safety benefit of seatbelts. Regarding the cost, there's a lot of questions about that, and that's what comes up a lot. When you extrapolate it out over the 12-year life cycle of a bus, you're talking it's roughly about $800 a year that it really comes out to be per bus, $800 a year. Now, when you think about cost also, in about 2 years, we're going to have a new emissions requirement that they can't change at the federal level. So it's a 2027 emissions requirement. That's going to raise the cost of school buses by $20,000. So what are we going to say at that point? We're just not going to buy school buses? No, we're going to continue to buy school buses, and we're going to say the cost is unavoidable. So if we can say that with our emissions requirement, shouldn't we also say that with seatbelts, which is arguably a greater safety improvement for our students? So we just have to make a decision to support them. So with that, I ask a favorable report on House Bill 110.
Thank you very much. Of course, Delegate Taveras, we all remember your star witness from 3 years ago. She was excellent, especially because she lives in my district. And we are joined by guests from the Ways and Means Committee, Delegate Patterson and Delegate Miller, who's sitting at the council table, has a question.
Thank you, Mr. Chair, and thank you for bringing the bill. I appreciate it. I did just have a couple of questions to clarify. So one, our school buses transport students from 3 to 21, the age of 3 years old to 21 years old. So, and I was looking into different strategies and different ways these seat belts, and you're specific in the bill as the 3-point seat belt. So are you talking about just the combination of a shoulder and a lap belt, or are you also talking about harnesses? And then how do you make those safe for a pre-K student all the way up to a 21, and accounting for all the size difference, shape differences, and special needs in between? and I'm sure other states have obviously done this, but there have been some instances of very, very significant safety concerns, particularly around small children, if they're not in an over-the-shoulder harness.
Okay, well, so this bill is advocating to make sure all buses have the lap shoulder 3-point belt.
Right.
As a standard. But most of us in the school systems all also additionally put into buses, certain buses, the 5-point integrated car seats.
Yep.
And so that would be for our youngest students. All the belts are adjustable to try to accommodate for the different sizes. So that kind of takes into account for the size of the students from the smallest to the biggest students.
Okay, yeah, so I just like to keep that in mind going forward, because obviously, for most school systems, we use our buses, unless we're talking about the small or mid-sized buses, which are usually for our special needs population, we do mainly use all the buses for all the ages. Then the other question I have is a lot, especially with the young children, I know from my own kids of putting in a seatbelt and putting in even a harness and putting in a car seat, that's really difficult. So are you accounting for, does the fiscal note, and I don't mean to direct this at you, whoever, do we know if the fiscal notes accounts for possibly another adult because of the timing of a child to get in, and especially if you have a lot of kids getting in and out of those harnesses, or making sure the seatbelt is adjusted properly, which is a big part of safety for children. Do we have any account of if that would be needed?
Well, what I can say on that particular issue is that the original law speaks to the training around how to properly put on a seat belt and train parents, train the kids, so that, because we don't want to necessarily have the bus drivers or the operators or the contractors and et cetera be liable, because we've exempted them from all liabilities, right? Because we really can't control what children do. But at the end of the day, if we train them properly, what we do know is that once children start to use seatbelts, the discipline improves within buses. That's what has been found via research. NTSB and other research have found that.
Okay, and then my very last question is, and I appreciate the latitude, Mr. Chair. We've heard about, of course, in rollovers or side impact, but my concern is in evacuation in the event of fire, flood, or submersion, because we get a lot of flash floods, especially up in my area in Frederick County, and so that is a real concern up in our area. And so how would you get those children safely out?
Right, so in some of the different studies and some of the different tests they've done, there really hasn't shown a much different time level to evacuate with seatbelts or without seatbelts in a normal circumstance. One thing they found, though, in some of those specific circumstances of a rollover or other issues, they've actually found more issues sometimes with the buses without seatbelts because kids get injured more.
Yes,
and so the injuries then prevent those kids from evacuating the bus, to whereas the kids in the seatbelt were uninjured, they can get off the bus. And, I think, just to go back to your last question, we're in the business of education. So I think our hope for all of our kids is they learn how to use a seatbelt, to whether they're in the bus or in their personal vehicles, that they can use a seatbelt all the time and know how to operate it properly. So we would, heavily work towards making sure all the kids know when they get on the bus how to properly secure themselves and get off so they can do it themselves every day.
Okay, thank you, Mr. Chair.
Delegate Frazier-Dabo.
Thank you, Mr. Chair. A couple of questions. Are you familiar with Montgomery County's electric school bus transition?
Yes.
Do they have seatbelts on all those school buses in their transition?
Yes, the electric school bus requirement in statute requires that they all come standard with seatbelts.
Okay, are you familiar with the utility grade storage backup program that's being done to back up the grid via batteries on school buses?
No, I'm not.
All of those are required to have seatbelts on them. Are you aware of the electric school bus fleets in California, Northern California, in Oakland, and in Berkeley? They have a bunch of electric school buses there. All of them have seatbelts. So, and Delegate, I don't know if you want to answer this, but when you grew up, did you put your seatbelt on when you got in a car?
I'm old.
Okay, I'm asking you the question. I'm asking you a question. When you first got into a car, did you put your seatbelt on?
No.
Okay, either did I. Now, my kids, as soon as they get into a car, they put their seatbelt on. That's what they do.
That's true.
It is really, really not that hard a concept to grasp. Just for FYI, Mr. Chairman, in case you didn't know, there are a couple people on this committee that know. I had this bill 10 years ago, and I heard these same arguments 10 years ago. Same arguments. The same exact arguments 10 years ago. And I'm a little bit furious with it because of exactly what you said, sir. Okay, so the school bus tips over, the school bus rolls over, it gets flooded with water. So they can unbuckle their school bus, they can unbuckle their seatbelt, and they can get out. Or they can lie there unconscious and drown. I mean, this whole concept of doing everything you can to stop putting seatbelts on school buses is an absolutely ridiculous argument to me. It is so ridiculous that I'm hearing the same exact argument 10 years later. Thank you. I don't know that I had a question, more of
Isn't that so?
Well,
just an explosion, Mr. Chair.
Just for the record.
Grant me the grace to say what's been bothering me. I appreciate it.
Just for the record, Prince George's, Montgomery County, and I believe Baltimore City are not the target of this legislation, since we've already voted to accept seatbelts on school buses.
There's about
As a policy.
eight jurisdictions in Maryland that have already gone forward with installing in their specs 3-point seatbelts. I think a big emphasis is not just that, but even when we do that, even on our own, that we have the protections for the drivers and the owners of the buses going forward.
And there is flexi seating that allows for the expansion of sitting and having greater numbers on your buses through flexi seating to expand that.
Delegate Boyce.
Thank you, Mr. Chair, and thank you, Delegate Frazier Hidalgo, for setting me up for this particular question. There's a couple pieces of testimony, and I don't like the fact that we can't see other committees' testimony, but because it doesn't make us better prepared. But there is one somewhat contradictory, and maybe I'm just looking at this wrong, testimony, and one is saying it's the Maryland Association of Boards of Education. They're in opposition to your bill because they have stated that about the requirement of all school buses purchased on or after July 1st, 2030 to be equipped with 3-point seatbelts. I think they make that mention, but then there's another letter that supports your bill with amendments, but in bold, towards the bottom, it states, the association also remains committed to the position that the yellow school bus is by far the safest mode of transporting children to and from school with or without seatbelts. Can you speak to that?
Well, without seatbelts is the concept of compartmentalization, which is the seating structure of the seat. The way the seat was designed was supposed to be safe as the engineering. However, over time, what NTSB has found through they did a study in 2020, 2016, 2012, and 2014 in different parts of the country that had significant rollover or other disastrous accidents, that there were greater parallelization, greater deaths, and so on. So this is why they ended up changing their national position from saying that buses were strictly safe as is to advocating for seatbelts. And that change occurred in December 4th, 2024, and I have with me the change in position.
Yes, thank you. And then and thank you for that. Thank you for putting that on the record. And then I want to talk to the favorable with amendments testimony from the Maryland Association for Justice. Did you see their testimony? They said, however, HB 110 creates a new immunity, page 5, line 32 to page 6, line 2, from criminal and civil liability based on the failure of a school bus operator to ensure that an occupant of a school bus was wearing a seatbelt.
From criminal to civil? Yes.
Yes.
We are trying to work with the stakeholders to make sure that we are sensitive to the needs of contractors and other stakeholders in the school systems who feel like they are, for any little thing, someone may want to sue. So we want to be able to set them at ease, recognizing that if we do the prep time in the front through training, exposure, and education, that we shouldn't have a problem, as the great delegate from Montgomery County stated. Now, kids are very well versed about how they, when they, enter a vehicle, the first thing that they're going to do is, put on a seatbelt.
No, I certainly agree, and I just want to follow up the last paragraph. It just says, because seatbelts save lives, and because the lives at stake in this context are the lives of children, it would be counterproductive to require seatbelts on school buses while also granting criminal and civil liability to school bus operators who fail or deliberately refuse to require the use of those same seatbelts. And it's for those reasons, they say a blanket grant of criminal and civil immunity undermines the laudability of the public safety goals of your bill. So
I think that I'd have to look at that.
I
I'll
just
be
wish
honest.
we could see other committees' testimony.
We'll see who we could talk to get a copy of those.
We'll get this. I'll get it. I'll send this to you.
Please, because I work with everybody.
Of course you do, and I just want to thank you for your persistence in this bill and bringing
I'm
it
like
back.
I'm a dog in a hunt. I don't let go of nothing.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this bill back. I am still traumatized from when I was in school and slid out the seat, and I banged my head against the side of the bus. But my question for you is, because I want to help figure out ways to do this as well, what about counties, and again, because I have a county that has 2 forms of government, and so in Calvert, they contract out. I'm not sure if this has been raised. What are the thoughts on just passing that down to the contractors and allowing the school systems to level up with them at a later date to help get this enacted? Has that been suggested?
So we are here with a representative. If you have information, if you have questions for the contracting piece, my concern, frankly, is that we have to treat our contractors equitably. Not every county treats them well. They may need them, but they may not treat them well. Some folks do, and some folks don't, right? And we just want to be sensitive to their situation, which is that, they want to, when they're negotiating contracts, they want to be able to, in good faith, incorporate the cost, the real full cost, and including inflation and CPI increases, whatever, into the cost for these seatbelts and every other feature, whether emissions or whatever, into the negotiated contract with the school system. And they don't want to be nickeled and dimed afterwards or not respected, because they are the ones that are taking out these loans, in the front end.
I understand, and I appreciate that, and I definitely don't want to sound anti-contractor. I know, particularly in my jurisdiction, we had a standoff between contractors and the actual bus drivers because of union negotiations. So I don't want to be unsympathetic, but I also don't want to make it seem as if we can't require that certain businesses do certain things. If you want to open up a restaurant, you're required to have certain equipment and licenses, and so therefore, I don't think that it's burdensome to expect that accordingly. But
No, but again, that's a completely fair statement, but you also want to make sure that if you feel you need them, you allow them to act in good faith and incorporate those real costs in the front of their contract so that they could take out real loans and not put them in a lurch halfway through their contract, right?
Okay.
Because you don't want kids standing in a corner in the cold.
Thank you. Appreciate you. Thank you, Mr. Chair.
Delegate Naraki.
Thank you, Mr. Chair. Delegate, thank you for the bill. I'm not sure if you've considered this point, but to my understanding, and maybe my colleagues from Baltimore City can correct me on this, but it's my understanding that middle and high school students, at least some of them that live within or more than 1.5 miles from their school, actually utilize MTA buses to go to school.
So that's why you don't apply?
Okay, so this would not apply at all to the MTA? Okay.
No, within your sphere, you guys are exempted from this proposal.
Well, I don't represent Baltimore City, so but I'm just trying to understand that for them. Okay, all right, so that's exempted. Okay, gotcha. Thank you, Delegate.
Delegate Anderson.
Yes, thank you, Mr. Chairman. Thank you for bringing this bill, and I believe that this would help. But the gentleman that's running the school system, is wearing the seatbelt required?
So right now, wearing the seatbelt required, so we heavily encourage it, but we don't have them on all buses, so we don't say it's a mandatory, but we heavily encourage it on all our buses, and we use it as a tool for our, for different situations that we have.
I just wouldn't want wearing a seatbelt be a requirement to use the school bus to get to school. That's I can see students, I'm not going to wear my seatbelt today. I'm not going to do that. Well, then they get put off the bus? Are they not allowed to ride the bus if they won't wear their seatbelt? I'm just trying to play devil's advocate.
I would say we have a lot of requirements to safely transport students. So there's many situations that a student can lose their riding privileges. Okay. If they're up on a current bus now without seat belts, if a kid will not sit in their seat and just wants to run up and down the aisle, then there has to be a way to address that, because that's a safety issue for everybody.
I was just trying to play devil's advocate with you, so thank you.
Delegate Anderson picked up this place really quick. All right, that concludes the bill hearing on House Bill 110. We will turn to House Bill 183. Delegate
Thank you, everybody.
Vehicle Laws, Vehicle Emissions Inspection Program repeal. Delegate Boucher, welcome back, and please go when you're ready.
Considering the two previous bills, I do not ride a unicycle, but I do wear my seatbelt. Good afternoon, Chair Corman, Vice Chair Guyton, and honorable members of ENT. Before I get started, I want to thank everyone for their empathy and professionalism yesterday. That was a very hard hearing, and I appreciate what you did for those individuals that are here suffering, so thank you. For the record, I am Delegate Christopher Eric Boucher, representing Carroll County and Frederick. The current vehicle emissions program is outdated, costly, no longer achieves the purpose for which it was created. Between emissions tests, additional MVA costs, and recent registration increases, Marylanders are facing financial barriers just to keep a vehicle on the road. Modern vehicles are already manufactured to meet strict federal air quality standards. Approximately 94% of the vehicles pass emissions testing each year, demonstrating that the overwhelming majority of cars on Maryland's roads are already compliant. At this point, continuing to require this program appears less about environmental protection and more about revenue generation. In fiscal year 2026, the legislative appropriation for the vehicle emissions program totaled $20 million in just labor, while the MVA retains ownership of the facilities, contractors manage staffing, equipment, and daily operations. Vehicle emissions program served an important role when it was first implemented, but automotive technology has advanced significantly since then, addressing many of the emissions concerns that originally justified the program. This year, the emissions inspection fee more than doubled from 14 to 30, further underscoring the financial burden placed on Maryland drivers, with a pass rate exceeding 90%. There is little evidence that the vehicle emissions program remains an effective and necessary regulatory tool. Most auto repair shops already have the technology to check emissions during routine services like oil changes. Using these existing systems supports local businesses and increases voluntary, more frequent testing. This allows emissions problems to be identified sooner, better protecting the environment while reducing unnecessary state spending on inspection, facilities, and staffing. Upon review of the financial summary, one can easily see that the vehicle emissions program is not about protecting the environment, but about revenue collection under the perceived false guise of protecting the environment. My goal is to work in a bipartisan manner to eliminate an unnecessary and outdated expense, reduce costs for taxpayers, and modernize Maryland's approach to environmental policy in a way that reflects modern technology. The fiscal note clearly proves that more than a third of the revenue collected is late fees. The existing business cash flow model is a failure dependent upon noncompliance. The note alludes to losing USDA federal funding with zero evidence, data, or analysis of such and how it will affect it. I ask you kindly to support this bill. Thank you. Any questions?
Thank you, Delegate Boucher. We have a question from Delegate Foley.
Thank you, Mr. Chair. Hello again, Delegate. I have two questions. One is, Maryland is not the only state that has emissions testing, correct?
Yes, ma'am.
And do you know, are there any other states where emissions testing has been repealed?
No, ma'am.
You don't know, or there hasn't been any?
I have no idea whether another state has repealed it as such as this or not.
Okay, thank you. And then my second question is, you referred to testing, emissions testing by mechanics, private mechanics. Is it your understanding that that testing is free?
Could you repeat that?
Is it your understanding that mechanics don't charge for that testing?
Well, they can charge. What I'm saying is it would probably be best, instead of someone waiting 2 years to have their vehicle emissions tested, and they could be polluting across 2 years. If the mechanics at the local garage offer that in their checklist when you get your oil change, you will actually be voluntarily complying to check your emissions more often than being state mandated. And I think that's the benefit on the private sector side, to actually protect us more than a mandatory inspection every 2 years.
But you would agree that a mechanic could charge for that, right?
Yes, ma'am.
Yeah, I mean, my experience is that whenever they do something, they don't do it for free, right? They charge you.
It's $30 now to get state inspection.
Right.
If you went to your local mechanic, he could have on a checklist $10 to check it.
Maybe.
I'm not sure. These are hypotheticals.
Yeah, of course.
But if you do go to the state inspection system and you have a problem, you wind up driving back and forth to be in compliance. This voluntary system would eliminate all that driving back and forth and allow you to address the problems right there when they're found by your mechanic.
Okay. All right. Thank you.
Thank you.
Delegate, I think states have to submit state implementation plans under the Clean Air Act. Do you know if the existing program is included in Maryland's SIP with the EPA?
I haven't seen anything to align with that or how it's connected.
Okay, because I just want to make sure we don't do anything that runs afoul of our federal requirements, because we have to submit this plan to the EPA.
In the fiscal note, there's an allusion to us losing federal funding, which is of concern to us, but there's no exact details of how that is. And I also believe that it's optional for us how we can comply to get those federal funds. It does not necessarily have to be the vehicle emissions program.
I agree with that, but we probably have to amend, if this is in our state implementation plan, we probably have to amend that plan before making the change. Otherwise,
I see what you mean.
Yeah. Delegate Fraser-Hidalgo?
Chair, and thank you for asking that question, because that means I only have one question instead of two, so I appreciate it. Do you support electric vehicles?
Yes, I support electric vehicles.
Okay, because that would make a lot of these problems go away, and electric vehicles aren't required to do this. You know that, right?
Yeah, you have no emissions tests on an electric vehicle. And it's nice to have the full matrix of these options for us.
Yeah, but the exception of the fact that the first part of the matrix is actually produces greenhouse gas emissions and pollution. So that's not the nice part of the matrix, that first part. That's why there's emission testing stations, right?
I'm losing you.
That's all right. Never mind. It's okay.
Any further questions for the delegate? Okay, we'll see you tomorrow.
Thank you very much. You all have a wonderful day. That was easy enough.
That concludes Bill hearing on House Bill 183. We'll now turn to the Vice Chair, House Bill 55, Vehicle Laws, Speed Monitoring Systems, Residential Districts. If you have a panel, please bring them up.
Yes, yes. Baltimore City, someone, yes, come on up. Thank you. Thank you, Mr. Chair, friends, and fellow members of truly the best committee here in the House. But it's very exciting to be doing transportation, and equally as exciting to once again be presenting a bill that I really don't need any notes on at all. I think Naraki is over there making plans with somebody, though, to punk me on this. Delegate Michelle Guyton, for the record, presenting you for your consideration once again, House Bill 55, speed monitoring systems in residential districts. So I'm going to make this very quick and easy and simple. This bill is a local control legislation. Currently, anytime a county wants to put a speed camera on any road that is not within a residential school district, or we haven't passed specific legislation for, they have to bring it to this committee. We have to decide whether St. Mary's County should be able to put a speed camera on a certain corner, or whether Baltimore City should be able to put a speed camera on a certain corner. It's inefficient, and it is absolutely not the best way to serve the people of any given district. We need the people, the police officers in particular, who are all in favor of this bill, to be the ones deciding what is in the best interest of the people that they serve, the ones who are the closest to them. So that's all the bill does. It is a one-word bill. It changes, it strikes all the different counties that already do this and just says everyone can do it. They don't have to have more speed cameras. And if they do have speed cameras, they still have to follow all of the regulations that have been put in place by this committee over the years. But they decide where they go. And that's really the crux of this. I do want to point out to you that while I do have some favorable testimony here with me, you have, I believe, 17 letters of support, including the Maryland Chiefs of Police Association. We have the Baltimore, well, you're here with us today, Pikesville Community Association, Baltimore County Government, Maryland Association of Counties, so MACO, for those of you who are not familiar with that, Frederick County, Maryland Coalition for Roadway Safety, Maryland Department of Transportation, many others, including National Federation of the Blind. So take a look at those. We have no significant unfavorable report. For those of you who are new, that means there are some people who just say no but write nothing, and that's not a convincing argument generally. And we have one favorable with amendment letter for you, which I actually absolutely agree with. That's from Michael Sakata, who says we should expand this authority to speed cameras anytime, any place. So thank you very much, and I ask for a favorable report on this bill, which did pass this committee last year and several other years in various forms, but this is exactly the way it passed last year out of this committee and the House. Thank you.
Okay, great. John Corn, Bicycle Advocates for Annapolis and Anne Arundel County, but again, representing Bike Maryland and a coalition of safety advocates from across the state. As I said on an earlier bill, this is especially important for people who are traveling outside of a vehicle, people walking, people biking, school children, people with disabilities using assistive devices, people on motorcycles. The difference of 10 miles an hour or 20 miles an hour can mean the difference of life or death for any of these vulnerable road users. So anything that will help reduce speeding on our roads is going to save lives. While fatalities overall in the state were down from 2024 to 25, 1/3 of the fatalities in 2025 were vulnerable road users. So we ask for a favorable opinion on this bill. Thank you.
Good afternoon. I'm Veronica Macbeth. I am the Director of Baltimore City Department of Transportation, and we support this House House Bill 55. The legislation is a critical tool in our mission to calm traffic and to save lives. HB 55 allows for the use of automated speed monitoring systems in residential districts, an approach that meets the urgent needs to address excessive speeding where we live, work, and play. And Baltimore's current speed camera use is very limited to school zones and weekday hours, leaving many neighborhoods unprotected, especially at nights when reckless driving often increases. In 2025 alone, over 23,000 citations were issued on I-83 between the hours of 8 p.m. and 6 a.m., highlighting the enforcement gap. And HB 55 would allow 24/7 automated speed monitoring in residential districts, helping cities like Baltimore reduce crashes and protect residents without over-relying on police presence. These systems don't just enforce, they actually change behaviors. So we urge you to support a smart, scalable, and safety-focused solution to address excessive speeding in neighborhoods across Maryland. Thank you for your time and consideration.
Good afternoon, committee. My name is Philip Mellerson. I'm here on behalf of Baltimore City as well. Speaking from a direct technical and operational experience managing an automated speed enforcement program. From a data and engineering perspective, residential speeding is one of the most persistent safety issues we see. Speed studies consistently show vehicles traveling well above posted speed limits, residential corridors, particularly on cut-through streets and during hours when traditional enforcement is limited. These are not isolated incidents, they are repeatable patterns tied directly to crash risks. Speed monitoring systems are effective because they are predictable, consistent in compliance. In Baltimore, once systems are deployed, we see measurable reductions in average speeds and decline in high-end speeding over time. That sustained behavior change, not in citation issues, typically a primary safety benefit. HB 55 does not mandate speed cameras. It authorizes local jurisdictions to use proven data-driven tools in residential districts while preserving local control. Jurisdictions must still adopt local compliance, conduct engineering reviews, select locations based on crash data and speed data, and comply with statutory safeguards. From an implementation standpoint, this bill aligns the law and real-world safety conditions and gives traffic engineers and local governments the flexibility to address dangerous speeding where people live, walk, play, and raise families. Baltimore City supports HB 55 and respectfully asks for a favorable report.
Madam Vice Chair, do you mind if I bring up MML before we do Delegate Naraki's cross-examination?
Thank you, Mr.
Thank you, Chair Corman. Good afternoon, members of the committee. Bill George with the Maryland Municipal League here today in support of House Bill 55. A lot of the points have already been covered. I'm going to speak a little bit more to the Vice Chair's point about providing local governments the option to choose their own path. There is already a robust and clearly articulated public transparent process in statute that needs to occur at the local level before speed cameras can be put into use. This is not a situation where someone from town hall is just out there putting out cameras because they feel like it. Local governments cannot use speed cameras unless they are approved by the council with reasonable notice and public hearings. And even before the cameras go into effect, the local governments must publish the locations of the cameras and install signage along the roadways where they're in use. This is really about empowering local governments to make the choices themselves over this issue. Currently, there are 52 municipalities out of 157 in the state that use speed cameras in school zones and some in residential zones as permitted currently under the statute. So about a third. So this is really a choice for the local governments to decide whether it's right for them or not. A lot are choosing to not use this authority, and that's okay too. But as to the Vice Chair's point, this is really, in our opinion, a local matter to be done through the local, transparent public process. With that, we urge a favorable report.
Thank you. We have a question from Delegate Naraki.
Thank you, Mr. Chair. Delegate, I'm not going to go down the pathway that you think I have here. I just have a couple of questions. If I could have 2 or 3, Mr. Chair, is that okay? Okay, thank you. I'm going to be nice. So last year, we passed a piece of legislation through this committee, a local bill for Baltimore County, but ultimately came through this committee with respect to 695 and 83. We placed some guardrails inside of that legislation that set boundaries to essentially how many you could place in a certain area, how many of these devices you can place in a certain area. Looking at the bill, I don't see any of those kinds of boundaries there, or guardrails, I should say. I know Baltimore County, for instance, doesn't have any of those, and I don't know what other jurisdictions around the state, but I know Baltimore County doesn't also have any of those kind of guardrails other than that they need to be in a school zone. So what would happen if the county, in this case Baltimore County, my county, I won't assume any others, wants to be really ambitious and put like 7 of them in one particular area? What would happen there then?
Thank you for that wonderful question. And as you can recall, so I'm going to answer this in 2 different ways.
Sure.
As you recall from last year and the year before and the year before and the year before, particularly in our delegation, what happened to this bill often was that it was loved to death by folks who wanted to put different parameters on this particular initiative, which made it different from the rest of the state, right? And it also took away that local control that we're really looking for here. So what happened was our chair last year actually, and the year before, I think, actually sent the bill back to Baltimore County and said, we're going to do this, but we're not going to let one county dictate things in a different way than all of the rest of the counties. So we're just going to keep it clean, simple, and allow those counties to have the local control to make those decisions. And that's what this bill does.
Sure.
I do not believe that that would be a very fiscally intelligent choice for them to put 7 cameras right up next to each other. I doubt very, very strongly that scenario would actually occur. However, in this process that is already laid out, there would be public hearings about that and traffic studies that would have to prove that you needed those 7 cameras next to each other. So there are a lot of safeguards to make sure that this is used with restraint. Thank you for the question and letting me explain that.
Yeah, no, absolutely. And so my other question of this, and so I have this in writing from Baltimore County. I know you and I have had discussions about it, so I'm not going to assume any other jurisdictions, but in Baltimore County, I have in writing from them that they utilize the speed camera program as a revenue generating program, not a safety program, right? They literally move speed cameras when they stop generating revenue. So how do we guard against that? Because I think all of us want these to be safety programs and not revenue generating programs. If they generate revenue, that's fine to the extent that they are slowing people down. But when you move them, and you put it in writing to me, and I can show you that where they put it in writing to me 2 years ago, when you put it in writing to me that we're moving them when they stop making money, I have a problem with that, and I think all of us should have a problem with that, because then that's not a safety program at that point.
Well, I appreciate that, because again, I like to clear up any misconceptions that people might hear out there about this legislation, and so I really appreciate the opportunity to do that. I think that your interpretation of what was said in that letter to me is inaccurate. We know, and you can look at the legislation, it has been in law in the state of Maryland for any jurisdiction that uses these speed monitoring devices for many, many years, that revenue has to go back to public safety supports. It is not a revenue generator. It is not a tax. It is going to specific public safety efforts and to pay for the program itself. So no one's lining their pockets with this money, because this committee made sure that that couldn't happen, right? And I have not seen a letter from Baltimore County that I interpreted in that way at all. And I believe we have the same letters. Okay, so what I believe that they may have said is they do move them around as they are needed. And as people change their behavior in an area, right, they will move them to another area. And the way they know they're changing that behavior is fewer people are getting tickets. That's not about raising revenue. That's about changing behavior and utilizing those resources where they're most needed. So I appreciate being able to expand on that a little bit more.
Okay, we can follow up offline. I know that we will. Okay, thank you.
We would enjoy that, yes.
Delegate Long. Thank you, Mr. Chair, and sorry to insert myself into a Baltimore County and Baltimore City conversation.
Oh, no, sir. This is a statewide bill.
I'm aware, but you have Baltimore County and Baltimore City at the table. I guess my question is to the director at Baltimore City. So would the council have to vote and then decide if and when cameras are placed? The city council.
Yeah, and I'll let Phil correct me if I'm incorrect, but if this legislation passed, it would not have to vote where the cameras are placed. What we would do is a detailed study, as Phil said, about the traffic data and speed studies as for whatever corridor that we're dealing with. So that's how we would go about taking a look at where the cameras would be placed, and kind of to go into an example is that, like, we typically do this over the course of, what, 30 days?
Yes.
Typically over the course of 30 days of sampling speed data in a particular corridor where we see traffic impacts. And if we see that a camera is needed there, that's when we would take considerations and put a camera there.
Okay, so can I come through a different angle? Thank you, Mr. Chair. So this is for MML, and here's my reservations, right? I'm not anti-speed camera, but I understand that all of us here represent various forms of government. You have commission, you have code, home rule, you have charter. And in a charter form of government, of course, we understand, and especially in cities, larger cities, there are departments that are geared towards administering speed safety programs. Take my county of Calvert County, for example. The sheriff's office would then be the ones probably putting these speed cameras up or determining where they're going. And so for me, that is just my reservation. Where is the structure for forms of government that aren't as vast and do not have the staffing capabilities to be able to carry out such a program? Especially because, I'm not gonna lie to you, I don't necessarily know if I want the sheriffs of Calvert County determining where speed cameras go, and I don't want to see black and brown people disproportionately affected, for the record. Thank you.
Sure, I appreciate that, and that is a conversation that we've had for many years about the disproportionality in these sorts of situations. I think the data shows that, in fact, this is much, much better than having people being stopped and having interactions with police officers for people of color. And that's no impugnment against police officers. I'm saying that that's what the data really does show us, that this limits those sorts of interactions and frees up our law enforcement for public safety of other kinds. But I also think you also represent Prince George's County as well, correct? They already have this authority. Your other district already has this authority. And if you, because many other counties do that are represented in this room. And if you look at the legislation closely, then every single aspect of how this will be decided is actually written in this legislation, not by this bill, but it has been in law for many years, right? This bill's not changing any of how those decisions are made, other than that the local governments make them, and not me making choices for your district and you making choices for mine. That's the only difference by this bill.
I understand that, and again, I'm not opposed to what you're
Yeah.
trying to do for your community. I'm just asking, and really for MML as well too. I may not know, or Mako can answer later, but how would a smaller county, who are mama may I forms of government that have to come and ask for permission for various things, then carry out a program like this? For example, again, because
Well, I would say they don't have to. They don't have to do it at all if they can't do it. I mean, that would be my answer, and I think you spoke to that already.
Right, and I can't speak for the different forms of county governments because we represent cities, but when it comes to that, there typically is an ordinance process that's done by the municipality to authorize that, or essentially to make it codified that there's been a formal decision made by the governing body of the local government that they would like to pursue this authority granted by the state. So there will be a broader ordinance passed that says, yes, we, the people of Annapolis, because here we are in Annapolis, the city council will say, yes, we're going to take advantage of this authority granted to us by the state, but we're not going to articulate in the code where the cameras are going to go. That's going to be a separate process that's done typically with, for smaller jurisdictions, they may have to hire an outside firm to do an engineering study or something like that, but that process is done typically separately. So the council takes advantage of the authority granted by the state through the ordinance process, and then the placement location is done through a separate public process.
Thank you, Mr. Chair.
Delegate Stein.
Thank you, Mr. Chair. In defense of Baltimore County, Delegate, I just want to read from a letter submitted in support of your bill, which I support, from the Chief of Baltimore County Police. He says, installing a new school zone camera has a positive effect on negative driving behaviors. It slows the vehicles down significantly and reduces crashes. So from that statement, isn't it fair to infer that if Baltimore County is moving a speed camera from one school zone to another, it's because the camera has slowed people down, has had its intended effect?
Exactly, and thank you for clarifying that again. That is what I was trying to help our colleague understand. They're not doing it for revenue, they're doing it because it works. And there's another place they could utilize that service.
Thank you.
Okay, that concludes the bill here on House Bill 55. We will turn to our colleague Delegate Healy, House Bill 58, Transportation, Paratransit Services, Interjurisdictional Routes. And if you have a panelist, please bring them up.
Good afternoon, everyone. For the record, I'm Delegate Ann Healy, and House Bill 58 is really something that I've been thinking about for a long time. And it actually is the reason that it's here this year now is that it's my last opportunity to lay this before the legislature. I hope that whether this bill in this form goes forward or it is amended to be a pilot program or study, I have identified a serious issue, and I would like to at least focus the attention of the General Assembly on this issue going forward. The bill addresses a structural inefficiency and actually an inequity in Maryland's paratransit system that directly affects healthcare, access to healthcare. While Maryland's paratransit programs are compliant with existing requirements and well-intentioned, they are organized in a way that often prioritizes jurisdictional boundaries over medical necessity. Under the current system, most paratransit services funded through the statewide Special Transportation Assistance Program are planned and delivered on a county-by-county basis. Eligibility, routing, and trip approval are tied to where the rider lives, rather than also including where appropriate medical care is located. As a result, individuals who rely on paratransit may and often are unable to reach hospitals and specialty providers that are best suited to treat their particular conditions if those facilities are outside their home county. This is not a marginal issue. Healthcare delivery in Maryland is regional and specialized. Major hospital systems serve multi-county areas and concentrate expertise for complex or chronic conditions. Transportation policy, however, has not kept pace with that reality. House Bill 58 is designed to begin correcting that misalignment. The bill does so in a measured and fiscally responsible way. As the fiscal note makes clear, House Bill 58 has no impact on expenditures or revenues by the state. It does not increase the statewide Special Transportation Assistance Program funding, create new entitlements, or impose additional state operating costs. Instead, it conditions participation in the existing program on better planning and coordination. At the state level, the bill directs the Maryland Department of Transportation to establish procedures that encourage cooperation among jurisdictions. This is an administrative and coordinating role, not a mandate to operate or fund new services. At the regional level, the bill recognizes that hospital networks and specialty care providers already function across jurisdictional lines. By identifying interjurisdictional paratransit routes to major medical networks. The bill encourages transportation planning that aligns with how healthcare is actually delivered in our state. At the local level, jurisdictions retain full control over how services are designed and operated. Counties continue to administer their own paratransit programs and make decisions based on capacity and need. The bill simply requires that when applying for these state funds, local governments account for interjurisdictional medical access and coordinate with neighboring jurisdictions where appropriate. The fiscal note properly acknowledges that local governments may face additional operational considerations. The transparency is important. It underscores why this legislation should be viewed as a starting point, not a complete solution. Meaningful implementation will require data, collaboration, and stakeholder engagement. I am more than open. I would encourage taking this legislation and using it as a basis for a study or a pilot program to allow those conversations to occur in a structured way. We need a system where access to the most appropriate medical care is not constrained by transportation silos. Rather, it should be guided by patient need. This is a practical step forward to improving efficiency, coordination, and outcomes within the existing framework. And I really hope that we can do this. I think we can do it this year with some amendments. And I hope that we can move forward because on a personal level, I experienced this. I now live basically in a medical care desert. I mean, when I moved, I've lived in the same house for a long time, since I got married in 1979. And when I first lived there, there was a hospital within walking distance. There was another one like 2 miles away. There was another one like 3 miles away. They're all closed. Leland Hospital in Riverdale closed. Prince George's Hospital, Cheverly closed. The hospital in Tacoma Park closed and was relocated to Silver Spring, considerably further away. The Cheverly Hospital, when it closed, moved to an area considerably farther away from where I live in Hyattsville. But I can get on Route 50 or 295 and get to the best hospitals in the world. And I'm fortunate because I have transportation in my family. My husband can drive me, I can drive myself, or I can find a neighbor or family friend to help me out. But if I were dependent on public networks, I might not have access to those hospitals or that kind of health care. And that's a shame because Maryland has the best health care in the world. And we have excellent transportation for a lot of things. And this is a gaping hole. And I think as a citizen legislature, our personal experience is something we bring as a value to this whole process to see if we can come up with a way to make our lives and the lives of our constituents better. So with that, I'm happy to answer any questions, and I'll be happy to work with the committee in any way possible.
Vice Chair Guyton.
Thank you so much, and thank you for bringing this bill and bringing this really, really serious problem to light for all of us. Something that I've been looking at for many years. I just wanted to ask you if you have met with the locals to the different counties and jurisdictions to determine which ones of them, because I know they do, have certain MOUs or systems where they can, and I want to point out this is very inconsistently, agree to take one person or another person across those jurisdictional lines for certain appointments. Have you started to have those conversations yet? Because they get very interesting very quickly.
No, I have not, because I mean, obviously that's one of the advantages of us coming from different parts of the state where we have different experiences with what's on the ground now. And I think that in the work group, we can probably thrash through some of those things. I know that where I live, we're covered by WMATA, and the current paratransit with WMATA will take care of a lot of people who want to go for their medical care in Northern Virginia. but they can't get to Johns Hopkins, they can't get to Anne Arundel, they can't get to the University of Maryland in Baltimore. Thank God we have shock trauma. We pay for that so that people who have accidents are helicoptered there when they need it. But we should have that for people who have chronic and serious issues as well.
Sure. Thank you so much. And I would love to be a part of helping create the solution if we do work towards a work group or as we're working with this bill. Thank you.
Thank you.
Delegate Lewis.
Thank you, Mr. Chair, and thank you, Delegate Healy, for bringing this bill. In the public health world, this is what we call a social determinant of health. Access to transportation contributes significantly to health outcomes, and you've made that really clear in language I think that my ENT colleagues can understand. So thank you. I'm also interested in advancing your vision for an integrated paratransit system, but I looked at the bill testimony, and there was a lot of support, a couple of favorable with amendments, like Kaiser Permanente is favorable with an amendment. That seems reasonable, and we can look at that. But there was one unfavorable, and it was from MACO. And as I read the letter, it says that MACO opposes the bill on the grounds that it mandates a one-size-fit-all requirement on counties. I didn't hear that in the bill, and I wonder if you could respond to that.
Well, as I said, this is a presentation of a vision, and I'm hoping to make it real. I would hope that MACO would come to the table and work with us, because really it's about cooperation across county lines. And yeah, there may be people in a rural area that, like, on the Eastern Shore that has to get to a hospital. It's going to be harder for them. They don't even have paratransit because they don't have fixed rail now. This is an opportunity for them to work with us to try to find a way so that people, who, no matter where they live in the state, can get to the kind of health care that they really need, as it's regionally built into our whole health system. We have an unusual health care system where you get a certificate of need for a specific kind of thing, and that reaches out to a broad area, and it should be possible for everybody to get to those high-quality medical care.
I agree, and I would just add, it seems to me that a couple of years ago, Delegate Ken Kerr put forward a bill to look at transportation networks or transportation, rural health and transportation. There's also the Maryland Rural Health Commission or Center. I'm sure they would be interested to think and talk this through. They've given some attention to it already. So I think there's an ecosystem of commitment, and I agree with you. We could probably work on something. So thank you once again. Thank you.
Thank you so much.
Okay, I do not see any further questions. We do have a favorable with amendment testimony in person, Allison Taylor from Kaiser Permanente, if she's here. Going once, going twice. Okay, that concludes the bill here on House Bill 58. We're going to turn to House Bill 8, Delegate Stewart. I think he's being represented by Allison Brown. Is she here? That's right, Delegate Stewart is big timing us and sending his aide. That's what he thinks about his old colleagues on ENT.
I love hearing that. I am a lawyer, though, so I mean, there's that. Okay, no worries. Okay, so and just so that Delegate Stewart has two different bills. The one that you wanted to start with was HB 68. Is that correct? I'm just reconfirming.
HB 8, I believe it is. We can do it however you want, but the witness next to you is HB 8.
I apologize.
He cares about bicycles, not license plates.
I apologize. Chair, Vice Chair, and members of the Environment and Transportation Committee, thank you for the opportunity to testify in support of HB 8, the Dangerous Driver Accountability Act of 2026. And so first, let me start with what this bill is trying to prevent. A family is driving home on an ordinary evening. A driver who has been caught speeding again and again, who has learned that tickets are just another piece of mail, blows through a corridor at an extreme speed. The crash isn't an accident in the moral sense. It's the foreseeable outcome of a system that watched a pattern build and did nothing meaningful to interrupt it until after someone was hurt. HB 8 is designed to create that interruption. What HB 8 does in plain terms is create a dangerous driver abatement program at the MVA for a narrow set of repeat offenders, people whose vehicles are recorded multiple times in a year for automated speed, work zone, speed, red light, stop zone, school bus, or railroad crossing violations. For that small group, the bill requires completion of an administration-approved driver accountability and safety course within a defined timeline. If the driver refuses, registration renewal is suspended, and continued refusal can lead to immobilization or impoundment until the course is completed. That structure matters. It is behavior-focused, not revenue-focused. It is designed to intervene early, before the next tragedy hits. Do driver safety courses actually change behavior, you may be wondering. The evidence is strongest when the course is targeted at repeat offenders and paired with meaningful consequences, which is exactly what HB 8 does. A peer-reviewed study of repeat traffic offenders found that recidivism-focused instruction was more effective at reducing both violations and crashes among repeat offenders than traditional accident prevention content. Large evaluations of speed awareness courses offered as an alternative to points and fines in parts of the UK found measurable reductions in reoffending, estimating that up to 23% lower in the months following the course, with effects that can compound and persist over time. It's also important to be honest about the broader literature. General post-license driver education by itself often shows little to no impact on crashes and systematic reviews. That's precisely why HB 8 is structured the way that it is. Not generic education for everyone, but a targeted accountability course for repeat offenders backed by enforceable consequences if they refuse to participate. HB 8 is the right tool. Because for most drivers, a ticket is a deterrent. For a small subset, repeat tickets become a routine operating expense. HB 8 recognizes that reality and introduces an intervention that is targeted, corrective, enforceable, preventative. HB 8 tells chronically dangerous drivers the state will not wait for a fatal crash to occur to take action. And for these reasons, I respectfully urge a favorable report on HB 8, and I thank you.
John Corn, Bicycle Advocates for Annapolis and Anne Arundel County, again on behalf of Bike Maryland and a coalition of statewide safety advocates. Same as you've heard from me several times already today, this is especially important for vulnerable individuals who are traveling on Maryland roadways outside of a vehicle, people on foot, people on bike, people with assistive devices. Any intervention that will modify behavior to save Maryland lives is something we should support, and my coalition is in favor of this bill. I want to thank you for using the term crash. We don't use the term accident. MDOT doesn't use the term accident. The National Highway Traffic Safety Administration does not use the term accident. We use the term crash because almost all of them are preventable. And programs like this will do just that. They will prevent future crashes. Thank you.
Great, thank you. And before I do questions, I will say in all seriousness, Delegate Stewart was texting with me. He's stuck in economic matters at another hearing, so he's not just being rude, but don't let him know I told you. Delegate Lewis?
Chair, and thank you for the great presentation. We'll be sure to tell Delegate Stewart you did a wonderful job. I have a question for the sponsor, and that has to do with something I think I might have missed it, but something I don't see. And in the bill, where it defines locations for the recording, for the, hang on, let me make sure I'm in the right place. On page 4, under line 18, section H, it says a repeat offender, the definition of repeat offender means an owner of a motor vehicle that within a 12-month period is recorded by, and then it enumerates a list of camera monitoring devices, a traffic control signal, automated railroad grade crossing enforcement system, school bus monitoring, stop sign monitoring, speed monitoring. But what I don't see is a camera bus stop enforcement. And last year, year before, we passed the long-fought bus stop, dedicated bus lane camera enforcement bill. And I would hope that if we're going to monitor dangerous driving, we would include the state's existing definition for dedicated bus lane enforcement, camera enforcement. I would love to see that. I wonder if that was an oversight or if it was done deliberately to hurt my feelings. So.
Do you want to?
You know what, let's follow up with the sponsor. You don't have to get in, you don't have to worry about Delegate Lewis's feelings. That can be Delegate Stewart's
I'll
problem.
pass the question on to Delegate Stewart to be able to give you a more robust answer.
We would support the addition.
Great. Any further questions? Okay, thank you. Good job, but don't go away, because that concludes the bill hearing on HB 8, and we will roll right into HB 68. Allison Brown on behalf of Delegate Stewart, Old Line Plate Program Act of 2026. And if you have a panelist, please bring them up.
Chair, Vice Chair, and members of the committee, thank you for the opportunity to testify in support of HB 68, the Old Line Plate Program Act of 2026. Let me start with a simple truth that we all know. Marylanders love Maryland. We wear the flag, we put it on our boats, our socks, our backpacks, and we put it on our cars. HB 68 takes that pride and channels it into something practical. New, dedicated transportation trust fund revenue, raised voluntarily, without raising taxes or imposing mandatory fees on anyone. Here's what the bill does. HB 68 creates an optional specialty plate, the Old Line Plate, modeled after Maryland's early 20th century plates, white characters on a black background. It's clean, historic, and distinctive. But what makes this bill powerful is the structure. Instead of issuing these plate numbers on a first-come, first-served basis, the Motor Vehicle Administration awards a limited set of 1 to 5-digit numeric-only plate numbers through public auctions. And the state keeps control. The state retains ownership of the plate and the number. Winners receive a revocable registration number right, not private property. And that matters because it prevents speculation, avoids a permanent secondary resale market, and ensures the value flows to the public. After administrative costs, auction proceeds go to the Transportation Trust Fund, helping pay for road safety projects, bridge repair, transit, and maintenance. So let me tell you why this is a smart revenue idea. Maryland's transportation needs don't wait. Roads and bridges age every day, as we all know. And capital needs are real. HB 68 creates a market-driven revenue stream that doesn't ask every driver to pay more. It asks only those who want something special to pay for it. This isn't theoretical. Nearby collector markets show that low-digit black plate aesthetics command real demand. Delaware's black plates are famous for it. In one well-reported case, a Delaware 2-digit black plate, number 20, sold for $410,000 at auction. Now, Maryland's program is better designed because it keeps the number public and prevents speculative flipping. But Delaware proves this key point. Scarcity plus design plus low digits produces real economic value. HB 68 ensures that Maryland captures that value for the Transportation Trust Fund instead of letting it leak into private resale markets. Here's why this won't hurt existing specialty plates. HB 68 is specifically designed with guardrails. The inventory of old line numbers is capped. There are no new plate numbers that are created annually, and numbers re-enter the pool only under defined conditions. That means that the program stays limited and does not compete with mission-driven plates like the agricultural or Chesapeake Bay plates, which fund important public purposes. Here's why a favorable report is warranted. HB 68 is the kind of policy that's rare. It's fiscally responsible, it's administratively straightforward, and it's publicly popular. It gives Marylanders something that they will genuinely want, and it turns that demand into transportation investment without raising taxes, without mandates, and without undermining existing plate programs. For these reasons, I respectfully urge a favorable report on House Bill 68. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce in full support of the bill for all the reasons that were just mentioned. I would just point out, so this is what we're talking about. This is what it looks like. Minnesota did this recently, and this is their plate. And in the first year, it generated around $7 million in revenue for the state. Indiana began selling theirs, and we'll share these news articles with the committee, but they began selling theirs on August 8th of this year. And based on a November report, so about 3 months, they raised $2.3 million in revenue for the state. And so given our budget atmosphere right now, we think that this is a unique and creative revenue idea that will, it's not going to solve all of our problems, but it'll help at least a little bit. And so for those reasons, Mr. Chair, we are supportive of the bill. Thank you.
Thank you. Allison, you may not know the answer to this, but we have a few different types of what I'll broadly call specialty plates in the state. We have the ag tag and the bay plate, very popular. They're kept in inventory at your MVA when you go. When you go to your car dealer and buy a new car or a new used car, whatever the situation is, you're able to sort of order those plates then and there. Then there are sort of the fun plates. There's some specific name for them, maybe association plates. So if I'm a Baltimore Orioles fan, I can go through a special process with the MVA and get a Baltimore Orioles bird on my license plate or my local fire department. The reason that the latter is okay and doesn't really compete with the ag tag and the bay plate is because they're sort of harder to get. I'm gonna have to go through this special process. They're not kept in inventory at the MVA. I can't just show up and get one the way I can the ag tag or the bay plate. So this sounds like it would work more like the Orioles bird and less like the ag tag and the bay plate. Do you know if that's accurate?
I believe that's accurate. What I said before about, it's the program is limited and it doesn't compete with the mission-driven plates like the agriculture or Chesapeake Bay plates, which also fund important public purposes. But, the state retains the ownership. It's just a license to basically use the plate.
Okay.
Mr. Chair.
Yeah, go ahead.
Yeah, that's accurate. This is not, the way the bill is drafted, this is not something you would just show up and buy when you go to the MVA. It would be an auction process, which is more akin to how Delaware does it. So more in line with the Orioles plate for sure.
Okay, Delegate Fischer-Hidalgo.
Thank you, Mr. Chair, and thank you for bringing up my chief concerns. A couple of things. One is I think that there is testimony that didn't end up on the system from Maryland Ag Foundation, Agricultural Education Foundation, as well as Chesapeake Bay Trust. So that's number one. Number two is that while I hear what you're saying, and I can have this conversation offline with Delegate Stewart, which probably would be more appropriate, I do have significant concerns that it is in competition with the ag tag and the Chesapeake Bay Trust tag. So we can discuss that, or if you'd like, maybe it'd be easier for me to just have that conversation offline with Delegate Stewart. Mr. Chair, do you have a preference?
I do. I have the testimony from the Bay, I think this is from the Bay Trust, the Chesapeake Bay Trust, which is not, it's not in opposition to the bill.
Okay, I don't have it on my system.
Yeah, but that's not your problem. You don't have to worry about that. We'll figure out what's going on with their testimony. We'll make sure we get their testimony. The witnesses don't have to worry about how to get testimony.
I can take it offline.
And yeah, I think we need to follow up with Delegate Stewart on this. It's an issue we all know about. We've dealt with this many times before, so we'll be able to work through it. No one is trying to hurt the ag tag. No one is trying to hurt the Bay plate. I hope we're not trying to hurt that Oriole bird license plate. Delegate Jacobs?
Thank you, Mr. Chairman. So I realize Delegate Stewart's not here, and I should probably ask him more specifically when I talk to him personally, but I want to verify that you said be 5 digits. Is that correct?
It's between 1 and 5 digits?
Yeah, that's drafted to the bill. Yes, sir.
So it's 99,999 possibility.
That is, yeah, technically that would be accurate. I think my understanding is that what the 5 numbers would allow you to do is you could do like specific numbers to identify that it's a Maryland plate. So you could start with 1111.
I understand. The possibility is 99,999 is what I'm getting at.
Well, it's 1 to 5 digit numeric only
5
plates.
digit.
1 to 5, meaning 5. No? Is that not what 5? I don't.
Yeah, you're correct. I think it is up to 5 digits on the tag itself.
Right.
Yeah, but MVA would, or the MDOT would control the amount that gets put up for auction.
But that's the possibility.
Theoretically, yes, but
Well, we have-
again,
we
given
have to
the
think
auction
that way.
style, it would be up to MDOT under
We
the
have to
bill.
think in theoretical means here. But, and so you say that it has no competition with the Bay or Ag Tag, but is any portion of this money, this auction money going to the Ag Tag or the Bay Tag?
I believe the way the bill is drafted is just to the Transportation Trust Fund currently.
So potentially 10,000 tags would have bearing on Chesapeake Bay Tag and Ag Tag if no portion of this. I mean, would you consider an amendment where a portion of it would go to Chesapeake Bay Ag Tag and Bay Tag?
We'd be happy to take a look. Well, I can't speak for the sponsor, but the chamber would be happy to take a look at any amendments.
That's all. Thank you.
Delegate Boyce?
Thank you so much. And I was going to say that it looks like the ag and the Bay Tag testimony was in Delegate Stewart's other testimony. I was confused when I opened it. I was like, why are they talking about the other tag registration? So it's filed, it's just in the wrong file. One. Two, I think what Delegate Jacobs is getting after, and we've had this before in the past, is should this process remove a certain amount of secure revenue that the Bay Tag would otherwise get? And let's say they take a dip of X amount of money per year when this comes out. Would you be amenable for having the money offset the cost that they lose due to this? I'm not sure that would happen, but I think that's the question being asked, one. And two, I'm a little slow, so I'm not sure how this works. So there is a finite number of license plates that will be made.
That's correct.
And that's just it. So after that amount has been sold through these periodic auctions, there will be no more made. Is that what I'm understanding?
That's correct.
Yes.
So, and also, just to your point, I'm not really sure that these really compete, because if I, and please correct me if I'm wrong, but the Chesapeake Bay Tags, that's like a $35 charge at the MVA. We're talking about $410,000, meaning like they are not at all. I mean, personally, I can't
understand.
afford-
I think I somewhat agree that they may not compete, but I
They
think.
don't compete, yeah.
Right.
Really.
I certainly understand it, but I think the question is being asked if for some reason it did or it does, would there be I guess, would the sponsor be amenable to offsetting the cost? I think that's the question. That's been the question that's been asked in the past about other tags. And so I'm not supporting one way or the other. It's just a question. But I just want to make sure I understand. There's a finite number of tags that are going to be printed and made with many different types of numbers that someone can auction on. And when those numbers are, that amount is done, this would be over, like this would not be. Unless, of course, there's a recycling of a car that's crashed or a car that a person is deceased in the tag, so that it would go back into the rotation, but there would be no more made.
Correct. That's the idea behind it. And so Delaware actually does this in a way that they let the individual retain possession of the tag, and then you can sell it at auction, private auction. And so the way this bill is drafted is the state retains possession, so the state would receive all of the proceeds from the auction. So you actually could have a situation here where not only would it not compete with the Bay Tag and the Ag Tag, it actually may just generate additional revenue across the board for the Transportation Trust Fund.
Right, no, I get that. And so to the point of Delaware, if I personally sell my tag, I get that money or the state gets that money?
In Delaware, the individual can sell it at a private auction. It's their personal property. Under this bill, the state retains control of the tag.
Got it, thank you so much.
Delegate Odom.
Yes, thank you, Mr. Chair. I'm along with some others in terms of the confusion in terms of finite number. You mentioned 5 digits, and so it was already pointed out by my fellow delegate about the possibility of 99,999, and I'm certain we'll get the answer to that. But then the illustration that you held up previously, that had an alpha, that was both an alpha and numeric, correct?
So this is Minnesota's tag.
Oh, that's.
Yeah, this is what they did. They enacted recently and generated a lot of revenue for their state. This does have letters in Minnesota. The one under this bill would not. And I think My understanding is that the way I read the bill is that regarding the finite number, is that MDOT would have the ability to, in real time, adjust that number. So if they, for instance, saw a revenue dip to the bay tag, they could limit the number, as opposed to making it finite in the bill and removing that flexibility that they would have to adjust, based on what they're seeing from a revenue perspective.
And so, but we'll get further clarification on that, Mr. Chair, what I understand. Okay, thank you.
Delegate Morgan.
Thank you, Mr. Chairman. Obviously, in this committee, I'm not going to point at you because Delegate Stewart knows these issues only too well. Did he just skip out on us today? But that's okay. It's a circular argument from Delegate Jacobs, Delegate Fraser, everybody, that what's going on. So what happens when you buy a new car? And would the dealership then be the one submitting the application with the auction bid for whatever the number's going to be, up to $99,999?
So the way the bill is drafted is MDOT sets up who can bid, like the bidder qualifications. I don't see this as a situation where you would be submitting a bid as part of a purchase of a new car. I think this is something separate and apart from that, kind of to the chair's point, where you wouldn't be able to just go to the MVA and get this tag. It would be a scheduled process like they do in Delaware. So Delaware, not only they allow private auctions after you purchase the plate, but they also have auctions. My understanding is every year they'll set like a time frame where people can submit an application at that point. So it's a little bit different than, you wouldn't be able to just go to a dealer and purchase a new car and the dealer would submit an application for you, is my understanding, the way the bill's written.
So when you buy a new car, the dealer submits the application, you pay a registration fee, a titling fee, and then say a week later you want to bid on the plate. That's another whole set of expenses that you're putting out along the way, correct?
An optional expense, yes. If you want to participate in the auction, you could then do that. It's not a requirement under the bill.
Okay, thank you.
Delegate Stein.
Thanks for bringing this bill. It's an intriguing idea. My question is about the auction. Does MVA have any experience in doing an auction like this? And if not, well, regardless, are they okay with this idea of being required to conduct an auction?
I can't speak for MVA. The fiscal and policy note does touch on this. They say there's around a $25,000 to $27,000 cost for the auction technology, I guess is how I put that. But the way the bill is drafted is that MDOT is made whole off the revenue they receive before the additional net revenue goes into the Transportation Trust Fund.
And not only that, but this has the potential to generate like tens of millions of dollars for the Transportation Trust Fund. So it's not like it's just like, oh, this is such an expensive thing to implement. Oh, MVA has no experience running auctions. Well, I mean, the thing is about this bill is that it generates so much revenue. I think we could teach them, how to run an auction.
Okay.
I don't talk quick enough to do an auction, but, we'll find somebody.
Thank you.
Delegate Naraki.
Thank you, Mr. Chair. Grace, so maybe this one's for you. So I'm just kind of reading the bill, and it might be in here, maybe I just haven't seen it yet, but what protections are there if we were to do this for an individual? Say I do go pay $400,000 for a license plate. What protections are there for me to not have it sort of summarily taken at any point just because the MVA doesn't want to do this anymore, or whatever the case might be? Just kind of would like to understand that a little bit more.
Yeah, I think there is protection in the bill about when the registration number returns to the state, and it's laid out. The way I read the bill, there wouldn't be any language that would allow MDOT to seize a plate after it's been paid for at auction. It would be up to the person to turn it back in.
Okay. I think it might need to be tightened up a little bit, but that's a conversation I can also have with Delegate Stewart as well.
I mean, I think that goes to the general question of how the license works.
Yes.
Because the bill grants a license to use the plate, that would be more not to the text of the bill. That's not really necessary for the bill, because the bill is specifically about the program. You're asking questions about the license, which is a separate issue. So if you had questions about how to formulate the license program, that would be a separate. That's not in the text of the bill.
Yeah, the only language I see around the administration suspending it is if you use it for fraud.
Right.
Yeah, I think Delegate Naraki's point is that maintain the ownership interest by the state creates a
Right.
little bit of confusion that we would just want to straighten out, which we don't need to do at this hearing. Delegate Healy.
Thank you, Mr. Chair. I have a little bit more of a question about the whole issue of problem of human nature. I mean, people's license plates get stolen off their cars all the time. And if you have one that's worth $400,000, what do you do if somebody steals it? If the state owns it, is the state out that money? Where does the money go? Or does the person who bought it for $400,000 just lose their money because somebody stole the license plate off their car? Or is this something that you're just going to buy it and put it in a safe or put it in a frame and hang it in a museum? How do you protect from that kind of thing?
So I think the way that Delaware does it, I mean, those are on those tags that sell for those prices. And there's only a few that sell for that high of a price, but there are quite a few that sell for, I think, north of $50,000. And they are definitely used on vehicles. If they were stolen, my understanding is, I mean, the individual who stole the license plate would be liable.
If you find them.
Right, but then the state could reissue a copy of the plate to the owner.
So then there'd be multiple copies of this one number that's supposed to be unique floating around.
Well, I mean, if you have a certificate of authenticity and then you revoke that certificate of authenticity, and then.
So it would be like a work of art.
Exactly, like to the same extent, like, you know, if you have 01, right, and 01 costs $410,000, and then someone steals 01, well, the state can then issue, you know, a certificate, you know, revoking the authenticity of that 01 plate, you know, for whatever reason. But the thing is like, I mean, you can't guard against theft in anything. Like, people will just steal. Like, is the state out of that money?
We're creating an attractive nuisance, perhaps. That's if we do this.
In exchange for tens of millions of dollars for this transportation fund, which has a deficit? I mean, maybe.
Okay, well, I'll talk to Delegate Stewart, too.
Okay, this is going to be one fun work session. That concludes the bill hearing on House Bill 68 and all the bill hearings for today. See you all on the floor tomorrow at 11 a.m.